That's right. That's right. His Royal Majesty in Teg. His Royal Majesty, owner. I may Bona. Some of these things and we want to fear on and fear. I mean, many so called I make a school, I na I remember you are no quality. Now, man, by you bluff over make a mali. Bona, I make a mali. No, boy, more than I can to Monoko Nike court to Sunday Nike ona. What can't know you try to the very best of our ability. I can go back blanona you kebak gummy. Bona, Bonia Feni, Mokotumo, madam. What I do know is Egabata, Egawo moto, Kepe, Egabata, screen there no. Ege, bluffo, Ege mali. Ega no quali and this and egba me. Bona, again, not take out to it. What I do know is they by you see, they are the kind of people you want of you and I'm a school and I'm a wagon or ya. Oh, you are making number chapbook big bioko no panny. Let check that home. Big bio, big bit. Ah, you a gansande. Ni Ajak or then you a gansande. Madam, what I do know is Bo challenge Ajak or Ajiakode, you gansani, madam. What I do know is Bo challenge Ajiakode. Bo, how dare you? How dare you? Anyways, but now we'll move on. Oh, in Kenya, is Royal Majesty in Teg and Nukwaba. Yeah, but people like her are why we do this. You understand what I'm saying? Koni wase kukamo ko chance video kaji batage and you blofoko ni care about the substance of the matter. Kono na at least need to try ke bag blami gamin keke onu shishi ojoba. Let's move on. Tumonye boni kebwe. Nkebwe ake menenge Supreme Court judgment bahabo. Wafen wana nibi na ya kumo echon lomo ke nibi we all saw what happened. You understand what I'm saying? Mine woni ebashe ene bashe nye inkane appellate court judgment ni jejemen ihabo nkebwa ke ni akesani ete court high court clearly ke okwe boni appellate court yele ke boni Supreme Court yele judge ni etano ye the high court judge clearly ebo omodi a split baby in the way they split baby it make sense. Now sometimes you have courts decisions come baniko ko banaka split baby but baby it make sense on aboni yo. In this case the way ni judge a high court split baby it didn't make sense at all. It didn't make sense because quite the fundamentals of the case clearly it didn't make sense about split baby. And of course no the honey appellate court strike na kaino down nini akete Supreme Court le Supreme Court affirm no ni appellate court rule. So just by way of a reminder, Sanene start from the Land Division Court, High Court. Like I said, Sempe win, you can tell because the greater part of the case ni High Court judge rule in favor of Sempe. You understand what I'm saying? Make sense because you cannot say Sempe and in one breath, then another breath of title ni alpha beta in it's legit. It's they can continue to hold on to the title. It clearly makes no sense because they Sempe Nihon Shikon alpha beta. You understand what I'm saying? So it cannot be okay Shikon chene oko Shikon yakomoko Shimon kemo ena title ya Shikon no ba Shikon like title anymore yeah title bakpani. You understand what I'm saying? Clearly does not make any sense. Shout out to you, man, Grace. Ona. So I get a appeals court alphabet I get and of course I strike everything from the lower court down. Ni a rule in favor of alpha beta. Ni a rule ha me Sempe no shishi. Sempe kete the Supreme Court a rule against Sempe in favor of alpha beta. And in essence the Gbawe stool Gbawe quarter family. You understand what I'm saying? So Sempe nye to mobeni anile amekete review. And like I said, they have a case. There have been multiple times. Bejaboboni follow these legal issues. Sani P Supreme Court no ameba rule one side. Eke akete review eke achakele. So I cannot say it is all over for Sempe. No, I cannot say that. Like I say all the time, I'm not a lawyer. I'm not here to play one on TV. I'm just trying to help my community. Some of these issues, I've never claimed to be one. It takes a lot of money to be a lawyer. In Yakonaka school, I will not assume, I will not pretend, I will not act like I'm one. You understand what I'm saying? It will be an insult to the people. Ni amefite shikana amete school. Ni amebachomo lawyer for you. So fine, a day lawyer Jimmy. I just try to see I break some of these things down. Koni as layman, one nibiye kome shishi ojogba. So I'm not here to give any legal advice. I'll just share my opinion. In judgment, as far as I'm concerned, there from the judgment and in a blame my judgment, I think it was like 1951 or so. Abanya claim she beja the Trinity ni at all Jamestown like Trinity ete ake amen fight ake a land may belong or to the Jamestown Trinity one out of the Trinity ni e claim shikon ni yo jeme. And that is why Nike Okane, the way any judges say interpret Akolache judgment. I'm a you clearly ake Appellate Court you Supreme Court you na kaino ake kenkani abo ba ake yes Sempe any produce document ni chon ake ama meke na kan shikonji lease government for poultry farm state farm say bona agricultural development corporation lele, but that alone it confer possessory rights on them. That alone, it confer possessory rights on them. Like I said, in Kanewoloko, from 1951, Nick clearly, Trinity, Trinity, wale. Ni ame take Gbawe on they will be able to win this case. She come Jamie. Akele yani fight for nekeshipon battle bawa, and clearly no jinoni the Sempe Stool is going through. You understand what I'm saying? Once again, I am not a lawyer. I'm not pretending to be one. My advice nikema Nii Otinto basane ni makele magalagani, if you can bring the Trinity back together, bona ni nyebaya as Jamestown Stool, then you would have a better and a much stronger case than Sempe alone. You understand what I'm saying? Shout out to you, class captain. You find a boy Ojuba. Now love Ishida. Lenwe back trash you. Uncle Ben. The Taiwan near me. Lenwu Eba. Ke niya ito kind bibio impa. You find a boy Ojuba. Bona. I don't know. Ake mene ni Sempe nkwewo because nye ekwewo. Supreme Court wolu far so can be nange noni ni Sempe sending na kan wa makane no ma abo no 9 pages it will be quick. But ni ke aleno ni osa o kwemi eko mene. Like I said, you'll be better off fighting under the umbrella of the Jamestown Stool than Sempe kometo ake amen ya ni ame ya fe na kan shikwa, because case ko eba ni a cover na kan jeme gbe fe ni aye against Gbawe, but I go le ekome as the Jamestown Alata Stool. You understand? Ne call na kan jeme gbe no ni na kan abanya use na kan no ni I'm not a lawyer. This is just a layman with a lot of reading. You understand what I'm saying? So ni ke o kwemie, if you can bring the Trinity back together, if for nothing at all, just for this particular case, I think you may have a shot. You understand what I'm saying? You may have a shot. Bona, Yes, you may have a shot. Oh, okay. Nanu. Ona. No ni we ni shipi e confirm ye me. Bona. So ni sempe o fine mi bodo man you fine boy ojugba. Inche. If you can bring the Trinity back together, I think you may have a shot. Because like a 1951 judgment in Kanye, clearly, o follow naka in case and you kwe Trinity no ba a better case than akoma je kometo enye ya sempe kometo enye ya ni ke alata un kometo te nwe bafe. You understand what I'm saying? Oh, okay, all right. Nyani wake wa legal expert aba no ni eba all right, so show a chaki wa legal expert eba bako oba kan shi eba it text me. So nyani ma trial ni boli wale audience okay nya wakwake wani ba share no. Yes, inche alaji over ne one board manye. Oh, over ne nya wa alaji. Yeah, papa over ne one board manye over ne Toyota. Inche over no again. Oh, let's nyani wa twale ko ngba over. Okay. And nyani, okay. Now wake alaji abana. Alaji ke you don't need a Trinity to establish your ownership. So now wake lawyer abano. Yeah, inje. Over yeah, papa onwe.
Minwe biane.
Eshe. Over ne yeah, engon na akashi oba. Nye le wani ne she what kind appellate court judgment. Pa Supreme Court no ba kan kula. Ba nye ni ne she if you make any nkabo you mentioned the last time we were US about that 1951 judgment there. Nin kan ye no wani mi we na kan because the way now she o kakashi dabi you don't even need that to establish ownership of nakan jeme.
Yes.
Okay, over keming bla ba.
Yes. No me kema relax kuni.
Okay. Animal can matter. Yes. No more by better because near appellate court I had a few questions, but so anyone can the water. Bona. No more. Yeah. Anyone can the water boy bano. Yeah. Isha. All right. Thank you so much. All right. Okay. Right. So Benyeli need a TV lawyer if he ready. So nyani without much I do. Nyani wabote amini wakania ke wakania attack ke wake lawyer e backpano bona ke e back blami once again boli need the TV the best of the best ona. So let's go ni wakani okay let's go so imbe no yo Supreme Court no yo. There you go. Okay, Supreme Court no ne. Boli. Ni be a fire man so. Okay. Man Beatrice, o find a Toyota, o find a boy or juba. All right, here we go. All right. So nyani wakania chan o fine kiamoko ni okiamoko ni mo aba ni ba butwe can he sempe nkwo ibana free legal not to say again lawyers but ibana another legal opinion ni ekole anye wa me case benyele wo lawyer if ready nyele wona ale she menele if ready so iba wa wo mene. All right. So nya wakania no ni Supreme Court take to mo boning blame habo from the very beginning be ole boni ebale so Supreme Court atigeme nyeno ni nkane abo na ejekpo Sempe Stool no shishi, so they took it to the Supreme Court. Mini Supreme Court now you would hear a lot of the things from the Appellate Court repeated here bona because it's the same case. So bana ganonima kane appear nyo bana kan kane chimo ihabo min kamoko ne for the first time I would want to read everything from the beginning. This morning my jump ni ma ya any decision by like I'm for the first time you understand, so can you feel like ene benye o kan de min kpa bofai permit me ekole ngmene moko eba kwa woni nye ekwewo. You understand what I'm saying? Ni esani enu no ni what shishi. Right. So ona korame be meaning ake ka I deliver no ko in korame means ake ni the entire court agreed. You understand what I'm saying on that decision. So many meta ni enone and clearly they all agreed on the decision. So noji no ni yo jebe many me make that particular ni said noji no ni yo je. So let's go on. Let's see Noniba. So once again, Nii Adote was substituted with Nii Adote Otinto. Bona, because Nii Adote, mind you, case is come I can case is come can be a fan bona fan babote ne ma min can be fan. And of course, mi den chempa Nii Ashali Asuku impa come pe Nii Yidoku the third ke onukpa me fan Sempe ball 3 division say ni yo Sempe ame fan ame fitai ke Nii Adote Otinto ni ame G defendants case na me. So nke abo ake a consolidate cases because cases p ni yo na kan kpokpa no bona moko ye 2 plot ye be moko ye 4 plot ye be moko ye 3 plot ye be moko ye 4. You understand what I'm saying? So afefe komi oni ayele nyunglo because it's still the same thing, still Sempe versus Gbawe into parenthesis alpha beta, same thing. Hello Osakaman estate in here pa me be no ba e ba jepo e. You understand what I'm saying? So it's the same thing. So abu afen na ni afe komi because moko ye 2 plot ye be moko ye 3 plot ye be moko ye 4 plot ye be. You understand what I'm saying? Then I can enclave them, you know. So let's start. Okay, there were 2 suits filed by the plaintiff / appellant / respondent, herein called the plaintiff against different defendants. Tumonye Boni Wana. Shout out to Ma Oti, Man Christine Ebatrashi. Akuche is in the building. Akuche Ebatrashi. So Tumobeni Kebu enye Benyeli. Case is to Benin Kebo, Banaka first one, ke second one. A fair come, no Benin Kebo, first one of Banake alphabet like 2-3 defendants. Call by second one, where alphabet like 6 defendants. You understand what I'm saying? So solo. But 2 separate cases. I feel come. So let's go on. With the same subject matter, but in separate suits, which the High Court consolidated for hearing together. Notwithstanding that the suits were 2, and by law 2 conclusions were to be drawn, the High Court used one conclusion to dismiss the plaintiff's claims in both suits and entered judgment in favor of the defendants. The plaintiff, dissatisfied and aggrieved with the judgment of the trial High Court, delivered on 15 March 2021, appealed against the same to the Court of Appeal. The Court of Appeal, in its judgment delivered on 23rd July 2024, set aside the judgment of the trial High Court and granted the relief sought by the plaintiff in both suits. The defendants, dissatisfied with the judgments of the Court of Appeal, filed an appeal against the same court to this court on 8th October 2024. So noni USCG mi fe noji noni wana ye BNN onani judge FA. So now background once again. You heard a lot of this from the Appellate Court judgment in Kanyabonye, but for the purposes of Ekole Mokoeba Fitawoi, ni elesani shishije, it will make sense for me to read it. Ekole nye show e mo na ekwe. Excuse me, keke na background there, Ojogba. So let's go on. In suit number FAL/558/2014, entitled Alpha Beta Education Center Limited versus Nana Osebonsu and 4 others, the plaintiff claimed for the following reliefs against the defendants: a declaration of title to all the piece or parcel of land in extent 5.20 acres into parentheses 12.85 hectares, more or less being parcel number 4, block 15, section 059, situate out South Odoko Estate in the Greater Accra region of the Republic of Ghana, aforesaid as delineated on the registry map number 004/059/1991 in the land title registry, Victoria Book, Accra. Recovery of possession, damages for trespass, perpetual injunction to restrain the defendants and their assigns and privies and workmen from trespassing onto the plaintiff's land. So, case in Alpha Beta, first one, eketene a little over 12 acres. Amanomi na kake, they have the title to the land. It was not acquired. It was not acquired through fraudulent means. I mean, I recover. Shikoji make me eba mama ni bi no me e damages me ba pe agbene we a perpetual injunction. I stop mo famo from going onto that particular land. The defendants resisted the plaintiff's claim and alleged fraud against it. Jemejeni fraud about primarily on the grounds that they knew they were in possession of the land and went behind them to procure a land title certificate. The defendants also counterclaimed against the plaintiff for the following reliefs: a declaration that the first to fifth defendants are the owners of their respective lands, described in their deeds of indenture given to them by the Sempe Stool as contained in the schedule below as the first to first defendants' land. Ninye iwe be clearly in Kebaka wameni wa yo man say nekino kone gba wana indenture. It's not enough. Fine, Masamatino Mieko, anytime ni abatwa na genu no mama repeat ko call man say no eshipon ye Ghana indenture. It's not enough. Famous search no face ake muni on shipon aha boy more lenye your title to the land ni ehwe ha boy ye shibami kan bo indenture pe ni indenture ofilake be no that is not it. You end up paying for the land twice. Me. It could happen to me. I'm a victim of that. I pay Ayabache Nkebo, same thing. Okaleche, same thing. You understand what I'm saying? So from a personal experience, you understand? Say me in den China awo ni what they were search na bi mo konklomo ni mo umba ni sampe shikun ko bona so fe lucky aka no miema konoko no imagine money manoko no na you understand what I'm saying? So me kpabu fai one man say bi enke ne no ko ne enyo wa ade nche indenture. It's not enough. Ke oye shikun moko abo indenture. It is not enough. Make sure ake money o shikun abwele honor title to the land. Then okay no kwama le kofe na kanye boni wana na komo me koma ni biye ofite shika thousands of pounds, thousands of dollars. Okay man no kwama shi ko e abani no na gbon papa ne ba ke okay bu e pay mo mi shipon ko ne ke do e shipon oba na ko ni ne ba nyehye. So nya wo fia careful wa de enche indenture. No nya wo bote ami. A declaration that the purported plotting of the first to fifth defendants' individual lands in favor of the plaintiff in the records of the Lands Commission was procured by means of fraud and or based on false representation. Once again, because Sempe menchono kwake na ken shikpon amame noni so keje amame hon shikpon aya Alpha Beta ke Alpha Beta in a title to the land there, then it means like Alpha Beta it used fraudulent means ni eke acquire na kind title and others setting aside a supposed land certificate number GA 38589 dated 8th May 2012 as same was procured by fraud. I can title it once again, registration title, certificate there na can ha me because ya me susu mo mi Alpha Beta na kan no ke get fraud mi awo ni achafo ni nye appellate court e bote into details ke quite no go by fraud boni esana yale gbenona sana chon money esani established na kan fraud there, and clearly that was placed on the defendants in this case, and judge they were able to prove the allegation of fraud against Alpha Beta Lands Commission. So nakano they lost. I mean, I repeat here, so you will understand. And others setting aside a supposed land certificate on G8 in Kanijamom, and other directed at the Lands Commission to expunge from its records the said supposed land certificate number GA 38589 in favor of the plaintiff and or anything incidental thereto. I establish I'm not like a certificate through fraudulent means say Afro Lands Commission when I'm a record sami perpetual injunction restraining the plaintiff, its agents, servants, workmen, assigns, and howsoever from interfering with the first to fifth defendants' enjoyment and possession of their respective lands. Konya face I stop plaintiff in this case Alphabida ni many amema moshia yeme alo ame yeshpo yeme Alphabida ekagba amena. So this is the case that the defense is presenting. Of course, I cost a harm. Any other orders this honorable court may deem fit. Now where I know. The original writ of summons was subsequently amended after a joinder application was granted, to include the names of Carolina Abebrese and Prophet Godwin Nuchuga as the 6th and 7th defendants, respectively. There is no evidence on record that the 7th defendant was served with the writ and statement of claim. The 6th defendant also counterclaimed against the plaintiff for a declaration that the 6th defendant is the lawful owner in possession of all that piece or parcel of land situate, lying, being at Dansoma, covering an approximate area of 0.08 acre or 0.03 hectare and beyond, and bounded on the northeast by a proposed road measuring 34.7 feet more or less, and on the northwest by Sempe Stool land measuring 100.8 feet more or less, on the southeast by Sempe Stool land measuring 100.7 feet more or less, on the southwest by Sempe Stool land measuring 38.8 feet more or less, which piece or parcel of land is delineated on the plan attached to the 6th defendant's deeds of indenture. Once again, indenture is not enough. You hear me keep repeating this anytime man like an indenture, because I don't want you or anybody close to you to fall victim with this old indenture business. This old indenture business. I don't want you or anybody close to you to fall victim to it. You understand? Keji Sempe turning case now around them. All of these people, I'm a farming in the Injunction. You understand what I'm saying? Because na ka indenture man, I'm a face search. Number kwake, name your title to the land. And like I said, unfortunately, some of them I put up properties worth thousands of dollars. You understand what I'm saying? Let's go on. A declaration that the purported plotting of the 5th defendant's land in favor of the plaintiff in the records of Lands Commission was procured by means of fraud and or based on false representation. An order setting aside the supposed land certificate number. So pretty much the same thing. It's like that. No one. It made a lot of sense. I put this case together. An order directed the Lands Commission to expunge. Same thing. In Kanifing Omo. Let's see if we can push it a little further. Now, subsequently, Nii Adote Otinto, head of Pako Berimawe, Nii Ashali Asuku Midenche Mpako Mepe, head of the Tete Peshiwe, and Nii Ayi Doku III, head of Sakachuruwe, all of Sempe Division of the Gun State, Accra, also joined as the 8th, 9th, and 10th defendants, respectively. They also filed their statement of defense and counterclaimed against the plaintiff for a declaration that the disputed land described in the plaintiff's relief, 1, forms part of a large tract of land belonging to the Sempe Stool. A declaration that the supposed land certificate number GA38589 of 8th May, procured by means of fraud and or based on false representation. An order setting aside the supposed land certificate number GA38589 of 8th May 2012, as same was procured by fraud. So once again, all the defendants are making the same case. You understand what I'm saying? So let's still, I'm here because it's repetitive. Now the second suit, it's the same thing. I think I get the mini word lawyer for use or Gbawe ni lawyer for use or okay, yeah. A declaration. The second suit with number LD/0794/96 entitled Alpha Beta Education Center Limited versus Reverend Mama Mercy and 7 others was in respect of the same parcel of land, which is the subject matter of the first suit. Like I said, same thing. So except I want 2 plot I want 3 plot I want 4 plot so it's like that same in you understand noni I'm ask for. It is the same thing. You understand? The defendants filed their statement of defense to resist the plaintiff's claim, and the 8 defendants also counterclaimed against the plaintiff. Once again, it is the same thing. The only facts they check is any shikon your keboli edale kenibi, but the case itself same particulars is the same thing. No go chakiko 2 suits and it made a lot of sense. I can consolidate. A declaration that a purported plotting of the defendant's land in favor of the plaintiff in the records of the Lands Commission was procured by means of fraud and based on false representation. Same thing. An order setting aside the supposed land certificate number GA3, same land certificate there, same thing. So let's go on. NMFA, like I said, is the same thing. Nakai. When subsequently what you meant ni amenye sempesian etena I'm about file ni I'm about fitai. So let's move it a little forward. Ni wabote ni biami. Okay. Now, the trial high court in its judgment dismissed the plaintiff's claim that when Gbawe Stool granted the land to the plaintiff's grantor in 2002, the high court had not decreed title in favor of Gbawe Stool. The High Court gave one judgment for both suits instead of maintaining the identities of the parties. The plaintiff was dissatisfied with the judgment of the trial High Court and appealed against it to the Court of Appeal, which reversed the judgment. Let's move on. The judgment appears on pages 77 to 114 of Volume 4 of the Records of Appeal. The appellant, dissatisfied with the decision of the lower court, has filed the instant appeal on several grounds, namely, the trial judge, after affirming that the plaintiff was entitled to a declaration of title to the disputed land, erred in not granting the relief of possession. Once again, they were need judge a split baby in Nake. The way they tell and thank God I can mean a lawyer be I've seen cases where a split baby and like a bad most of the time it make sense. But I know shikoni. Shikoni. You cannot say I get mokome as title to the land. I get mokome as possessory rights to the land. It makes sense. They have feel it. How come me and Yoni am in fight here? Mokome can have title to the land and Mokome can have possessory rights to the land. I don't get it. You understand? But I'm not a lawyer. I didn't go to law school. I keep repeating it. I'm just a layman reading. The trial judge erred by holding that the defendants were in possession of the land. The trial judge erred in holding that the Yaudwade, in which judgment was given in 1963, granted possession of Akukor Foto lands to the Sempe Stool. Once again, I'm glad I can lawyer idea so we can deal with this case. From a perspective that the judgment was against the weight of evidence. Once again, in judgment is against of evidence. Judge evidence now provide produce a arrive at a different conclusion than none arrive at further grounds of appeal will be filed upon receipt of a copy of the record of proceedings. The facts of the case, which are not in contention, are that the plaintiff in November 2003 acquired a sublease of 90 years from its lessor, Osamampa Estate Developers Limited, containing an approximate area of 12.950 acres or 5.240 hectares at South Odoko in the Greater Accra region to put up an educational complex. The plaintiff's lessor acquired the land in the form of a leasehold from Gbawe Quarter family for estate development and registered same at the Lands Commission. So once again, Osamampa Estate ne ame eshikon ye Gbawe biade ni ame in turn ame ke alphabeta. So Gbawe hon shikon ke Osamampa Estate. No Osamampa le hun ke alphabeta. Once again, lease. Boli ahon where you are shikon wake up. So the plaintiff's lessor acquired the land in the form of a leasehold from Gbawe family for estate development and registered same at the Lands Commission. The plaintiff's sublease was registered and a land title certificate was issued on it on 8th May 2012. The plaintiff testified that she subsequently found the defendants occupying different portions of each land and brought the actions against those she found on the land. At the same time, others also applied to join to protect their respective interests. The relief relied heavily on a court decision delivered by Judge Ofwe as it then was, as a judgment which confirmed the interests of its head lessor, Gbawe family, who leased the land to its lessor, Osamampa Estates Developers Limited. The defendants denied the plaintiff's claim and testified that the plaintiff's lessor's grantor lacked title to convey title to the plaintiff and its lessor. The 8th, 9th, and 10th defendants in the first suit, who were also the 9th, 10th, and 11th defendants, who are the grantors of the other defendants, asserted and testified that they are title to the land and their title was confirmed by the decisions in Nii Adote Otinto versus J.A. Quay in suit number which were the respective suit numbers of the case they won in the High Court, which was affirmed by the Court of Appeal and finally affirmed by the Supreme Court. The High Court evaluated both the oral and documentary evidence on record and concluded that the plaintiff proved the declaration of title but failed to prove the other reliefs and was accordingly dismissed. The High Court further granted only possessory rights for the counterclaimants, which had been affirmed by the case of Nii Adote Otinto versus J.A. Quay, and dismissed all the other reliefs sought by them. The High Court gave one judgment for both suits instead of maintaining the identities of the parties. The plaintiff was dissatisfied with the judgment of the trial court and appealed against it to the Court of Appeal, which reversed the judgment. The grounds of appeal filed by the plaintiff against the judgment of the High Court are as follows. The trial judge, after affirming that the plaintiff was entitled to a declaration of title to the disputed land, erred for not granting the relief of possession. The trial judge erred by holding that the defendants were in possession of the land. The trial judge erred when he dispensed with the composite plan which had been drawn to aid the court in arriving at a just judgment. This composite plan, there are a lot of things in a composite plan. A lot. If you know some of the cases, New York, Nakanjame Bear, no, you understand what I'm saying. That is why I agree with Alaji sometimes. Ninka Alaji, the last time, bo money I represent, bo lawyer and represent, bo is any ochuoni odobani, onyo provide lawyer with every necessary information possible. Every necessary information possible. Le coffee na ke obana ke oye case, but coffee lo jubo bana ke okesheko. The trial judge erred in holding that the Adote case, in which judgment was given in 1963, granted possession of Akukor Foto lands to the Sempe Stool. The judgment is against the weight of evidence on record. Now, the grounds of appeal filed by the 1st, 8th, 9th, 10th, and 11th defendants in the first suit and all the defendants in the second suit against the judgment in pursuance to leave grant by the High Court on 20th September 2021 are as follows. Well, I repeat the same thing, so I'm skipping anywhere. Ninka waste of time. But the same thing, no, the first one, the same ground say no, no go check it. Okay. Now, the Court of Appeal discussed all the grounds of appeal filed by both parties. It concluded that the judgment was against the weight of evidence on record, the inapplicability of the case of Nii Adote Crab versus J.A. Kwe, which traveled from the High Court through the Supreme Court, and the applicability of the High Court's previous decision in the consolidated case of Nii Adote Otinto II versus Itami Limited and 4 others, and Nii Adam and Nii Adam Quarter is not Kwesi Quarter versus Itami Estates Limited and 2 others with suit numbers L215/2001 and L219/2003 respectively. Let's go on. Okay. Yani no. Ufane be ojani fe mo boken hamoko bona. Now, which had previously granted judgments in favor of the disputed land, and Nii Adam Quarter, the plaintiff's head lessor, who was the 4th defendant in the first suit and plaintiff in the second suit. The Court of Appeal reversed the decision of the trial High Court, except for the declaration of title to the land made in favor of the plaintiff in both suits, and granted all the other reliefs sought by the plaintiff. The court reversed the decision in favor of the defendants in both suits. The defendants in both suits filed an appeal against the Court of Appeal's decision on 8th October 2024. The grounds of appeal filed are as follows. So agbene no na make ba Supreme Court ni Supreme Court akwe ehame because Appellate Court rule against ame ne that the judgment is against the weight of evidence adduced at the trial. Their lordships erred in law and misdirected themselves by holding that the decision of Judge Ofoe, as it then was, is of potent legal force and binding, when indeed the said judgment ignored the principle established in determining disputes with respect to Jamestown or Gallant in Akwe versus Abebio 1927. In Kebuake, I think I'm a child the numbers game jo number no. So noni case ne feji yake ke eba gashikon jiye ano akọ saying ebi yejeme eche ni ameifa yejeme eche akọ na kan no na akọ ake okay because shikon ne tete say we be wabanye what trust ame kaya show ni ame fire be wa ni ame tuni ye be wa wabanye wa ka ne ke shikon ne amame no na kan jiboni ke bale aja na kan gashikon jinye na kan ajale. You understand what I'm saying? Namoni baje me first namoni we be fire je me na me nje me che bona e ka ba ke okay ke wa kwa bi bo ono ne bo nke wa kwa bi bo obi na me ba ne ke no eche I mean Jemmy for a long time. I mean fire Jemmy wa so bombo no ne na kan so sempe I mean appeal and I'm afraid to the Supreme Court in Kakadabi kaji judge ekwe ne case name Akwe versus Abebio 1927 e ba follow na kan legal statute allo precedent that's the way I should put it na kan precedent ni e ba no shishi no na me ko Akukor Foto ama me no nie. You understand? And other decisions all affirmed by the Supreme Court in the case of Jamestown Allata Stool and another versus Sempe and another 1989 to 1990 Second Ghana Law Review 393. Let's go on. The holding by their lordships of the Court of Appeal that the defendants / respondents / appellants took calculated risks by constructing their respective houses on portions of the disputed land against warnings issued to them by the plaintiff appellants respondents was perverse and ought to be set aside. Now, nyenin kandi abu emi bana ke ni judge you chono kwa ke afobida biamini ome na ake me eboy eba na amemamo ameba kamoko bashipon no ame ha mo warning na me call mo ake dabi shipon no ka start no ko why shipon ni me ko me botwe ni amete no na me mamai so no juno ni ame yu ake dabi akabo no ni ame yu etwe ake ka me warning me de nche me ya no na me mfini having acquired their grants from the allodial owners, the Sempe Stool, and having completed and occupied their respective properties without warning. Once again, and BNA is very, very critical. And the judgment kokla declare Akukor Foto land ake Sempe the allodial owners of the land allow the Jamestown Stool. You understand? And once again, in Kebake, Jamestown Stool, a bullet Trinity. You understand what I'm saying? Trinity. Nyeni wakande naka appeals court no onu yamin farm. Ake yes, the Trinity as it then was, Sempe was part of it. You understand what I'm saying? She ani no give her possessory rights to any ame call. And this is one of the things though I try now but I deal with whether yes Sempe is part of the Jamestown Trinity, but and that alone grantor a lawyer ownership can particular shipon. You understand? And that is a very good question. Obabi alaji uni wakwe jomochomo ye noe. Let's go on. The Court of Appeal erred in holding that the defendants/respondents appellants failed to prove fraud against the plaintiff appellants/respondents. Their lordship of the Court of Appeal failed to appreciate that Akukor Foto lands form part of lands generally known as Latebi Okoshi lands, also known as Mimete lands. So this is what Sempe is saying. Akukor Foto lands it forms part of the lands generally known as Latebi Okoshi lands and also known as Mimete lands. So that brings another question. Keji, it forms part of Latebi Okoshi lands. Mimete land say, how then do you say you have sole possessory rights to that particular land? Because Latebi Okoshi lands, Mimete lands, once again, Trinity about me. You understand? Then you have to think about the Trinity. You understand? Because some of the cases say no kombote no komi, no kombote no komi, no kombote no komi, no kombote no komi. These cases are very, very difficult. You can read the more ni be a flash or you oichomi, you ni be flashy, ni be pin flashy. You understand? Let's go on. The Court of Appeal discussed the law on consolidation, relying on its previous decision in Gbawe versus Fiancun 1995 to 96, First Ghana Law Review 278, and concluded that the trial high court judge erred by delivering a single judgment in both suits without stating the conclusions he reached in each case. The above decision provided a guidance for consolidation at page 281 as follows: to enable the hearing to be facilitated and expedited, that a separate judgment has to be delivered in both cases. The individual identity of each of the consolidated suit has to be maintained throughout the proceedings up to execution. So this is where you clearly onake judge apply the binding statute ni a cover consolidation of cases clearly. With this noni akotine a chonwakelele judge isani treat each case distinct from each other, even though I trafe komie basani koine eke dealing with any eke koine eke dealing with any she fe ne me fini efe komie without clearly dealing with it. So this legal statute achonbuake judge a follow bonum. Pleadings filed subsequent to consolidated suit as to clearly specify in which of the consolidated suits it was being filed. The above guidelines are not exhaustive, but we shall also address other important conditions. Let's go on. The cases to be consolidated shall be two or more with a common question of fact of law, or facts or both, and share similar issues of evidence. Clearly, the same enclave, the cases shall arise from the same transaction or series of transactions or the series of events. clearly in a cover. The cases must involve the same or common parties or witnesses. Same thing. It must be made to prevent inconsistent decisions from a court of coordinate jurisdictions. The cases must be pending before the same court of coordinate jurisdiction. The consolidation would avoid multiplicity of actions. The court may order both to be tried at the same time or one immediately after the other to promote efficiency and convenience to save time and resources. An application for Yani, this is all about the law, talking about the consolidation. I think again, appellate court deal with all this in Notwithstanding that the High Court judge delivered only one conclusion in both suits, the Court of Appeal cured that defect by rendering two findings in each case. So once again, KG case is bad. Yes, you have the right to consolidate it, but shall not treat fair distinct from each other. Ni appellate court annually. On again one skipping it because ni kandi agbla fair mi na kind defect elele akio. Discussion on the grounds of appeal. The defendants commenced their submissions with the omnibus ground of appeal to the effect that the judgment is against the weight of evidence on record. They established jurisprudence of the courts regarding the omnibus ground of appeal is that an appeal is by way of rehearing. It mandates an appellate court to rehear the facts of the case and any legal issues that would require facts to address them and are being impugned, correct, or the errors alleged to have been committed by the court below and come to a conclusion supported by law. The errors to be corrected and the omnibus grants of appeal by an appellate court to come to a proper conclusion that accords the law include facts that were not properly evaluated, facts which ought to have been evaluated but were not evaluated, and any wrong application of law to the facts, including burden of proof, which occurred in a miscarriage of justice. The cases cited by both parties to address the omnibus ground of appeal include Abe and others versus Entry 2010, Supreme Court Ghana Law Review 17. So on authorities say na aside the settled law is that a person who alleges that a judgment is against the weight of evidence to demonstrate the errors committed by the court below should have them corrected. However, where there is an error which is wholly unanswerable but was not raised by the parties, an appellate court in seeking to do justice can address it. On the other hand, where the matter is answerable, the court may invite the parties to address it before a determination is made. The defendant's first submission under the omnibus ground of appeal is that the Court of Appeal's evaluation of the two judgments, which confirmed the root of title of the parties, was against the weight of evidence on record. Apart from ground E of the appeal, the defendants argued all the other grounds of appeal under the omnibus ground, they appealed against Nakanofen. The High Court consolidated the cases of suit number Nii Adote Otinto the second versus Icon Limited, Icon Estate Limited, IK Mafu, Nii Adam Kwate Quarte, Nii Ayikan the second, and Nii Adam Kwate Quarte versus Icon Estate, Edmond Kofi Sowa, Nii Adote Otinto the second. So there you have it. A lot of the cases were wrongly applied in favor of the plaintiff. And if the errors are corrected, this court would conclude that the plaintiff was not entitled to the relief sought and obtained against the defendants in both suits. Defendants further submit that they referred to two cases to support their case, but the Court of Appeal misapplied them. The defendants claim that the confirmation of their title through consolidated suit number TRL number 22/19, once again, our side case again, we traveled from the High Court through the Supreme Court titled Yao Duade Crab, the third plaintiff, Ejakwa, co-plaintiff, versus J.A. Kwe of Accra, defendant, Nii Tete Beshi, the second, Sempe, co-defendant, and Duade Crab, the third, plaintiff, Na nan ejakwa the second court versus so another case I'm in chono kwake so don't can you find chono kwake defendant saying this case the Sempe Stool and the rest now I'm on the other side there chono kwake keji judge he applied these cases say ojogba if I reach a different conclusion than he did. So these are the cases say no nani aside fame. The defendants relied on the consolidated case above, which traveled to the Supreme Court as the judgment that affirms their title. At the same time, the plaintiff also relied on the High Court consolidated case determined by Judge Ofwe as it then was. The defendants, in their written submissions, argued that the Court of Appeal judges were misled to hold that the judgment of Akolache J, Judge Akolache, that the Supreme Court affirmed did not confer possessory rights. Do not confer possessory rights on the Sempe Stool when it conferred possessory rights on the Sempe Stool, whom the 8 to 10 defendants in the first suit and the 8 to 11 defendants in the second suit derived their interests and transferred same to the other defendants in both suits. So I mean target dabi Akolache case nete Supreme Court nyenin kan appellate judgment abo efele fanga ke na kan no mo ka o kan lodge ba actually Sempe lost in that case. They didn't win. So no koni ame win here. If you're telling ame site or na kan no ake no jinoni ame shid ame domono ni ame ke claim or na kan no nye appellate court ruling here, it was very onaga nowhere far. So the plaintiff rebutted the submission of the defendants on the effect of the judgment of Justice Akolache that did not create any possessory rights in the Sempe Stool, and the position taken by the Court of Appeal is correct and should not be disturbed. What been our water? In a 23 pages, but we're 19, so 4 more to go. Okay, what a lawyer bano. Then what I can't no needs to pick about if time back permit to. Another show. A look at the entire proceedings reveals that Justice Akolache's judgment has been mentioned in all the pleadings, and the defendants who allege that the judgment decreed possessory interest on behalf of the Sempe Stool have the burden of proof on the preponderance of probabilities. Because this is a civil case, so it is not beyond a reasonable doubt. Sections 11.4 and 12 of the Evidence Act 1975, I quote here, are the two important provisions on the burden of proof in civil matters. The case of Ajubeng versus Domfe, 1996 to 97, Supreme Court Ghana Law Review 660, in giving effect to sections 11.4 and 12 of the Evidence Act 1975, NRCD 323, held that the burden of proof in civil matters is proof by preponderance of probabilities. The defendants have failed to prove that Justice Akolache's decision of the High Court, which the Supreme Court finally affirmed, was relevant to the land in dispute. The defendants, who claimed that the judgment legitimized their title, failed to prove the same, and furthermore failed to prove the source of their title, having found that the judgment of Justice Akolache up to the Supreme Court did not affect the disputed property. So, like I try to get but let's go on. Additionally, the defendant's grantor asserted its title by stating that it granted a lease in respect of part of the land to the Agricultural Development Bank on 12 January 1959 or 1960. Once again, ni wana wali yake court here awo mi yake by the mere fact akeshi amamena meha ADB I'm a lease na kan jeme ke ha me no etwon ake be na kan shipon amameno. It does not grant possessory rights to them. Once again, remember the Jamestown Alata, the Trinity. Remember it. But Alaji Kewake, you don't even need that. So the original date of 1959 was crossed out in pen and replaced with 1960 without initials. So once again, even I can lease put in chair now make ADBA. Original date 1959 for me. Ni ake pen it replaced 1960. Ale money for me because mo initially ake mean for me. Ni me initials ne. Ona. Koni abanya chemo na be like mini one for me. So anybody could have just, you understand? No, talk about the oath of proof was not executed before the register of deeds. There is no oath of proof by the register of deeds. Consent of the president of Gun State was not sought and has not executed the lease. The concurrence of the Accra Municipal Council has not been sought, and the fact that the town clerk of the Accra Municipal Council has not executed the lease. Because look, KG about go by these standards say, maybe because you and I know very well, okay, neke procedure ne, this very procedure ni court rape ni president of the Gun State, Accra Municipal Council, town clerk of Accra Municipal Council, registrar of deeds, can be any other. Go no follow neke na you be me pay she pon is bye. I guarantee you, most of the lands in Accra, again no konemi, bonnie sane chomi. Once again, because can I boy indenture no ma indenture no ma. So any me face so nege no koneni cotton hold the Sempe Stool by trust me, keji I hold keji I hold it I hold it mo fame every land transaction ne teno. Ye Accra by neke standard in ona sanani ba jemi ne bona je no go bibio let's go on. No payment was made to the lessor contrary to section 72 of the Municipal Council Ordinance of 1953, which demands that all revenues from stool lands with the municipal area shall be collected by the council concerned. The lease breaches second 19 law work about it. The lease breaches section 7 and 8 of the Land Title Registry Ordinance, Cap 133, on the proof of the instrument by the oath of the grantee or grantor or the witnesses, and the proof before the registrar of deeds or judge or magistrate, and was found to have been fraudulently obtained to establish recent occupation of the land. Justice Ofoy declared it fraudulent and further found that the Sempe Stool had not been in possession of the disputed land. Look, this particular portion in Kanyabwe, a lot of the stools, she can't on Sunday bye. Keji yakra fen chobwe. Keji follow neke strict ni judge justice say you be ne no go bibiu. Now let's go on. The plaintiff traced its roots of title through its head lessor, Gbawe Quarter family, as the owners of the land, and corroborated the acquisition with the judgment of Ofoe J, as he then was, which was appealed but subsequently abandoned. The judge on page 57 of the judgment found as follows, and this is where Tomoboni were Sempe, this is where their trouble started. This particular case, they made the huge mistake by not. I don't know. I can Nii Adote Otinto can hamie. Nyegweke na de kamakani no de kiamie. But well, they actually appealed, but they did not follow through. So Appellate court ruling there. Ayuake mina chole a strikeout na can appeal for want of prosecution. So I strike out. So I may appeal him more, but they didn't follow through. They didn't. So court had to strike it out for want of prosecution. You understand what I'm saying? Judgment in here. So I don't know. We'll see. We'll read that one. As the authorities state, until the Gbawe Quarter family can provide evidence of a better title, the possession which is in Sempe will have to be upheld. Did Gbawe provide such better title? I've stated that the tradition of evidence of ownership led by Gbawe was not challenged. I find the plaintiff's unchallenged tradition evidence probable. They supported this evidence with the area plans, Exhibit B and C, There was no serious or convincing challenge to these exhibits. Akukor Foto falls within the large tract of land Gbawe claims by the unchallenged evidence. It is my view that by the unshaken traditions, evidence the plaintiff, Nii Adote Otinto, placed a better title to the possession of the Nii Adote Obuo's Sempe Stool. So, on and on near UABA. One, let's go on. The trial high court judge made a declaration of title in favor of the plaintiff, as the plaintiff proved their case by the preponderance of probabilities through oral and documentary evidence. The plaintiff's head lessor has been declared the owner of the disputed land, and the lease made in favor of the plaintiff's lessor is valid. Once again, this particular case is what messed Sempe up. Unani Appeals Court Justice said the same thing. Supreme Court reaffirmed nakano pepe. The Sempe failed to prove any interest in the disputed land, and its grantors are bound by NEMO that code no head back. They required no interest in the land. NEMO that code not head. I think it means you cannot give what you don't have. You cannot give what you don't have. So Kesempe Benakaino, they cannot give it to anybody. If they don't own it, they cannot list it out. Let's go on. The counsel for the defendants further submitted that Justice Ofwe was bound by the Supreme Court decision and that he had given the decision per incuriam by departing from it. Decision per incuriam. It means the judge follow precedent. Yeah, a follow precedent. Allow if a follow a binding legal statute. Ni kanji follow nkwe. Eba arrive at a different decision. You understand what I'm saying? So nakanji bene enwashika ke per incuriam. Arrive at the decision per incuriam. Ni tragebe judge follow a precedent. Allow a binding legal statute. Ni kanji a follow nkwe. Eba arrive at a different decision. Justice Ofwe did not depart from the decision of the Supreme Court, bearing in mind the doctrine of judicial precedence. There you have it. The judge stated only that the land determined by the Supreme Court was different from the disputed land, and that the defendants failed to prove that the subject matter of both suits was the same as the disputed land. The defendants have failed to prove any lapses of the Court of Appeal, which reversed the substantial part of the decision of the High Court, and the omnibus grant of appeal on which the defendants heavily relied is dismissed as unmeritorious. So, Supreme Court and Kawan Okwake, Sempe Sandiana make ba Supreme Court. So far, I nyeko na chono kwake noni appeals court we esani ame you. So far, nyeko punch holes. Yeah. Appeals court decision ni no webani ame Supreme Court ame dumononi ame ke chake no na we so ame kake ame dismissal because it's unmeritorious. No mi ma kokla be ni amanya ame dumono na ame ke no actually. The defendants argued ground E of the appeal, which provides that the Court of Appeal heard in holding that the defendants failed to prove fraud against the defendants. Once again, be kayo appeals court take that be alphabet any prove akeshipon but we be on ame. I mean, I may prove akeshipon but we be no ni but we be no ka me na title be title ja no sempe bi on get that be to be na me yo shipon we no mi ka abo title ba ju so no you know ni justice is Supreme Court jameji any ame she bi ane. The defendants submitted they were in possession of their respective lands, validly acquired from the grantors, Sempe Stool, before the land was leased to the plaintiff, and that the land certificate issued to the plaintiff should be declared void as having been fraudulently obtained. A person who acquires a land title certificate in respect of a land acquires an indefeasible title, but it may be set aside on grounds of fraud, mistake, or any of the vitiating factors, so and therefore creates a reputable presumption of evidence of title of interest or interest of the land. So I don't know like keji onyeshipon ni onye title here, that title is indefeasible. Meaning, I hold all nagan title make up wake no nye lele be shikon bo no mi no ko be ni ebanye ni eba je na kan no ejeme ni abaka ke shikon job except I'm about to except ake you are able to prove ake na kan no ona through fraudulent means. Although there are other vitiating factors, same thing, vitiating factor. You understand the word vitiating means ake no koni enyo a chaki or noko. You understand? No koni enye kumo noko, no koni enye fiti or noko. So okay, accurate decision there. A vitiating factor is a factor ni eba fite na kan decision there. Eba ren na kan decision there useless. Eba bole chafu ake that be in a jomobemi. And therefore creates a reputable presumption of evidence of title or interest in land section. That is why in Kebo Dana indenture is not enough. Title, when you have title, it gives you the title is indefeasible. You understand when it comes to owning a land until approved otherwise, until there are vitiating factors. You understand? I.e., if you are able to prove okay, nakan shikon money on fraudulently, you understand? But title, so come on indenture, ya no face search, you na ojugba dienche. You understand? Section 138 of the Repealed Land Title Registration Act 1986, PNDC Law 152, provided for 2 grounds upon which a court may invalidate a land title certificate. That's fraud and mistake. So you understand? Vitiating factors say, allo no ni ebani a title to a land if a defeasible. No, do you know ni PNDC Law 152? It make like be there must be fraud and there must be a mistake done. But at the time the action was instituted in the High Court, that was the prevailing enactment. And the person who could prove fraud or mistake against the holder of a land title certificate. The same position holds under the Land Act 2020, Act 1036, except that adding either vitiating factor could also impeach a land title certificate or a land register. The legal effect of registration of title has been discussed in litany of cases, including outside authorities. The law is settled that registration or title certificate is a prima facie evidence of title to an interest or rights in, to, or over immovable property that can be impeached where fraud, mistake, or any other vitiating factors is successfully proved. So once again, come on, title is prima facie. You get prima facie on the face of the evidence. That's pretty much physically. Okay, you own the title. I don't need anything else until I challenge you. Once again, then you can get prima facie on the face of the evidence. At the go, okay, Sandy and Kenny, that's prima facie. So there you have it. So come on, title no trouble. I call and I can ask it. It is indefeasible until you prove fraud, mistake, allow any other vitiating factor. You understand what I'm saying? The defendant's case is that they were in possession of the disputed land before it was subleased to the plaintiff, and that this amounts to fraud. The defendants could not produce any titled documents to disclose their interests in the land, thereby failing to give actual notice to persons who may seek to acquire an interest in the land. So, Sempe was unable to provide title to the Akukor Foto lands. That's it. So, Gbawe enye register na amekia moko ni mo acquire title bonyo kake mo na le fraud because bonyo provided title to the same land. There no kake bono. You have no title to that particular land. This is what the court is saying. You understand? It is the defendants could not produce any title documents to disclose their interest in the land, thereby failing to give actual notice to persons who may seek to acquire an interest in the land. It is not a mere allegation of fraud that would constitute proof of same. So no kake any another true fraud no you cannot just no. The defendants could not lead sufficient evidence to prove fraud whose burden of proof is proof beyond a reasonable doubt. Once again, onakeke fraud then ochakele from being a civil case to a criminal case. In criminal case, as you well know, the standard is proof beyond a reasonable doubt. Unlike a civil case, on the preponderance of probabilities. You understand what I'm saying? So once you identify alleged fraud, it becomes criminal, and you must prove beyond reasonable doubt. Derivative speak 1889. At citable. The defendants failed to prove that the plaintiff made a false representation with knowledge that it was untrue, and that it was made with the intention to deceive the defendants, who relied on the false representation by the plaintiff, and as a result of which the defendants have suffered loss or damage resulting from the deception. The allegations of fraud made against the plaintiff are without legal basis, and the facts provided by the defendants to prove it cannot constitute fraud. The ground E of appeal is equally dismissed as unmeritorious. So nakano awo echafun because nani damo nobe enoko beno ni abanya domono nakake noni ayuo nakam. All the grounds of appeal filed by the defendants against the judgment of the Court of Appeal delivered on 23rd July 2024 are dismissed as devoid of merit, and the said judgment is hereby affirmed, signed, on a certified copy. There you have it. Ene lawyer Aikwe Otu, Yafita lawyer Emmanuel Hammond ni ameno Sempe in this particular case. So there you have it. Pretty much for about 3 hours. Supreme Court efe nakano pepe so chameka nyame nyani wafia careful wameni wa yo man say ene me akafio wada nya wafia careful ye shi ba mi nyani what a lawyer ni woke lawyer abakpa no ni eba educate wo. Let's go. Hello, Alaji. Papa. Oh, you wanna do? Agbene, online FA clear. Agbene, thank you so much once again for taking time off. Ni over join wagmene uni o educate wo. Ochon wani ojugba. Oyana walada. Agege bale nege sani elege. Ke wa fambo no oba. Ofane so far initial comments here. Noni what can you know? Nani yesani enyo etenko ni mabibo gege. So what bote mi work so far only initial comment so far mini jinoni obanyo care wo ye this case any agbe. Now before no ba channel now mind you keji ole Sempe me apply for a review, so agbe ko na kula okay I may apply for a review okay so ni akwe okay so that's what it is. So offer anyone wo agbe ne
can claiming menu kobo ke otubule fin hife na meyo mingamo femo if you make kejanye you start
that's right
ake o kandi judgment you initially like Supreme Court judgment you can yoshi later on you realize that it was the appeal court judgment you know ni blame uchoma mbiye ni like obomodin wa kemi blame obomodin wa denche
thank you
wa denche
thank you
we feel in such a way I can feel about no shishi. See sometimes una boni judge say bulldog case case they appeal the first thing that the judge does is a back blame ne ke boake money ke saneti money akeleti court money ke saneti court no ne ke ne isanene ka domo koteji eneke etoni mukumecha ha lehu nune.
That's right.
Sometimes legal gymnastics komeni ya no kote hu kote banana li ekume utini o mi e ba na le e ko le dibi ko mete no na te Supreme Court asa be ko e ba gbele hin e fe ejeme una then secondly then the court will now come to why you have made the appeal. No, the reasons for your appeal will also be stated. Yes, stated and then bako jeje baha emini a full ruling interpretation. No, she JFN call can if no na fen J no ni jeje call you no call.
That's right.
Bele no nete no in the past. Ken chombo ake neke no ni mene ken no lawyer fu ke neke. Then agbene ba boy a judgment te hamo.
That's right.
The second another thing mani allergy. Case koke land case the court. Ni bi ete jino ni court ba akwe. Ni akwaye sanie ni bi ete ni ba dumono nanu kwaye bi.
That's right.
One neji identity of the land. Nando ba na ke describe land there. Obana ka turn from one point to the other, measuring this feet. Can it be title last state? So the description is very important.
That's right.
When the judge say they also repeat it.
That's right.
To let you know that this is the description of land that we are talking about.
That's right.
Or it's under litigation.
That's right. So I came again next time and can skip it. So next time get ready. No touch you can go no.
No. Oh, now the extent of the land.
That's
land
right.
1 acre can do, 2 acre can do, 3 acre can do. One plot, quarter plot, it must be stated. No, I guess I know what describe land.
That's right.
What describe the land there? What should one look at the court? Or lose or more than back court.
Okay.
No, identity of the land is very important.
Right.
Then second thing, huni abanya dumonoji possession. Possession. In some cases, say possession is 9/10.
Okay.
9/10 in what? In winning your case. No, you only on your proof possession. Bench about 1/10.
Right.
No, but win no case. No, possession is very important. No, a person who is deemed to be in possession. A person who is in possession of a land is deemed to be the owner.
That's right.
Except someone proving better title. Except. Okay, for 200 years. Nimbo konye prove better title for boy. You are the owner.
That's right. Okay.
Naga no long care. No matter how long you stay on somebody's land, you cannot rip into ownership.
That's right.
No, ka oche boko shpon huwe e chombo noche. No possession. Did the second one.
Right.
And the last one, which is very important, is a root of title.
Okay.
Shipon imo nakeje. Ya he Oshimashide. Oshimashele umbe nakeje. Enime ke na me bato ahu. Enime ke na me na bato ahu be na bato je na mo yo jen. Jeme ko ni moko bejeme root of title. O chon he ni chpon je dan de ba shodi.
Right.
These are the three things. If you mean. Show ownership the land okay sanitary court. Now when you prove these three you are good to go.
So we have identity, we have possession, and we have root of title. These are the three main things. Nii Adote more.
These are
in legal
demonstrate the court.
Your land battles army. Okay.
Exactly. No, o fail root of title. No chon ni o shpon na keje. Definitely you don't have a case.
Right.
And that is what we have read now. Gantos enyonano. Ni Sempe Gantos. Gbawe Gantos. Na me no. Ewo wanake no cheme petese na me chi owoji ha me client e na achon court we. Ye na wa ya agbene efien na ageshi ni Sempe ba join ni. Ona no na wa ke be na wa join na pebe be efin ji no sana ji ehin.
That's right.
Ona you no law okay when you sit down for someone to fight your battle you are deemed by the results. You are bound by the results.
That's right.
Your court touching no hanimboku ya tataku habwe. no friend ba na kan ta mi bo hu emo bo sa ohi.
That's right.
No na te ne anja fa bita lose nku. Gbawe no ne lose.
Gbawe, that's right.
Na kan ni.
That's right.
No, well, man link no ni with the question that you asked earlier on about the Trinity. Okay, we needed the Trinity here to fight these cases. History is history. Whether the Trinity is there or not, we can win the case without the Trinity now, but with the history of the Trinity.
Okay, that's right.
No need to know your past. You know about
that's right.
You don't need to. We don't need to form the Trinity and say okay. Because at that time,
that's right.
He had Trinity. He's the lead. What do you call it? Chief for the Trinity.
Okay, and that is definitely impossible. That's not gonna happen. Yeah.
Exactly.
Yeah.
No. As for that one, we cannot do that.
But can they? I mean, just for the purposes of this battle, can they not still come together as Ekome without necessarily need about because you know, but it affect the other stools any yo nakai Trinity and you know your Jemek because the way Gbawe will be a set. I mean, you don't know money any. Sometimes I mean, Sempe next time, you know, with Gbawe being and there are pending cases coming between Gbawe, this Trinity will be in no, you know, a lot of them are caught still. So don't you think a common understanding ni Trinity just for the purposes of this battle ni about fair komeni about no neke no mone
it will render a collateral judgment irrelevant.
Okay.
In the sense, justices of the court, I mean, during the Privy Council era, I'm a much like I'm a lega, Shipoji. I'm a no no
yeah.
Ostane no ba kele, no ame dumono, na meke boasa jinye. No, for instance, bemini, neke issues of Trinity ne, issues coming out no nake amenta na me agbeleke ni bi insagien te court especially any sympathy ahe that you callable compensation ona le if smart na fe no savile ahe compensation ko ba ka jeje no chine ahe compensation na akwuji ake okay bi ebo no ni no ke le no ni e ka bibu ake okay bi no fe e bi yeah compensation na ahe mi ahe no, that's a possession. Possession does not mean physical structure.
So inche. But no. Why not ni a working in this case where ni amenkakeshi amamelisi that chikoni yo Jamaican ha State Farms ni akefe poultry farm in the 1950s, early 60s. Kaji amenyame a compensation from Kolebu. Ni no work in their favor na menya me grant take na no ya me no me me no work in this other case where na me nkake keji okwaje me work at least ADB in 1960 ni wo a compensation e gbompo wonta why me no work in this particular case don
this particular case already there is an existing judgment which is latest in time that is Justice Ofo judgment in 2006
yeah.
Whatever went wrong in that judgment, as for the Supreme Court, they are bound by it. Okay, more history. Okay, moko possession. More root of title
right.
Ona actual possession. Possession you know the ADC. Now, how did you come by that land? It's your history. Sane okay na kanje manwa ba. Ono counter Gbawe no ne ha. Ni mi na bilake ake my lord. We came to meet our grandparents and they told us that our great grandparents, the name of our great grandfather was Osiakwang. Okay,
yes.
I'm a great grandfather Jimmy Osiakwang. He came with gun to settle around the place called Patakole before they moved to the seashore. He was a hunter and came with the guns who migrated to that place. During his hunting, he was taking ownership of those lands. So it was through hunting that he got the ownership of the land. he was asked, now, this ancestor of yours, this ancestor of yours, which you have just spoken about, did he marry and to whom according to your traditional history? They answer, my lord, he got married to a woman from Obutu, and the name was Nede. At the time he got married, it was the Obutu who were living on the Gbawe land. My lord, when the clan of Obutu were living, they left that parcel of land to my ancestors. And it was through this woman that we all came from. The land, according to plaintiff, covers from Gbawe Pehe to Gbawe to Gongpata and continued the Winneba Road. No history of this piece of evidence were not challenged. This piece of evidence were not challenged. History. Don't give your history. Your history or root of title. What is it? So possession alone cannot guarantee you success. Or any challenge yo.
Right.
No, DNA was someone no. Malaysia no was someone no. No, if a fast they are he mini Kolibushka na ke ni bo ahe wo be okay bia habu. Ama kebonoko sempe ka akumaje asremeni.
That's true. That says the history. That's a fact.
That will be who know na me asremeni. They ni ba na make a cross na me fo the road there, the other side of the road number settle on the other side there of the Koli Lagoon and they established themselves with the Sempe and Akumaji.
That's right.
Now make a wale fe womini English alatade. This one my back to my head. I make a wale fe wo English alatade. English alataba show the head stool over the two. Sempe ke Akumaji. Ni ameke fe ni BP ahun kashi beni kojale bio the fourth you know. And let me tell you what happened. Don't know this issue is important. Now Oblogo 1916. 1916 there was a ferry at Oblogo. Ni me ta mi kefo Oblogo ni Jidensu River. Me da me be weja ni abasa nu na nu ele ehu ni da.
Right.
Wo ferry jino na ke manu yin na afo ni ahioshika. Oblogo bi nke so Oblogo. Gbawe bi enter Oblogo. I'm a trespass keba na kan shpono.
Right.
Ni ujale bi odije the fourth ekesani eti court. Ni ekesani eti court what happened? Sempe bi bami. Number challenge. I think not only Sempe and Akumaji. Mene lack capacity ni English alata.
Right.
He came in for himself and on behalf of the other two. Ni ake fight Oblogo Shpoji. The two others too, Sempe Kakumaji Keo, a better capacity because Jeme were claiming Jeme. Ona, no court na keshi okay, it means that if Nyekeshi Yahakule Hewale, Lewa Banye claim ye Jemakele as Alatai, Banye claim. No, I don't need to know case ete son agbenai. Then about challenge capacity.
Okay.
In law, capacity can be challenged at any time.
At any time.
Judgment over challenge capacity.
Okay.
No, they succeeded. So they have to non-suit Kojabebu, his capacity. Not suit Leko Kebasanieni.
Right.
As what? As Alata alone, because it was his subject who went to what? To found it.
Right.
Now non-suit le. No, in this case, will you tell me that I have Oblogo here? About the Trinity here. We don't need the Trinity. The history is there.
The history is there already. Right.
You made mention of the Nemo Dat Code non-habit rule.
Yeah.
That you cannot give what you don't have.
That's right.
This principle was used in the 1916 case. Trespass name. Because no me na both is an ni Oblogo 1916. But we ke na kanje me Oblogo lante no. No Oblogo lante ne ba agbo ne ufe will ye na kan shpon no ha mini e ha ankra. Ni koja e do challenge akeshin. E ke no. Bo oblogo na tie shmo je bo no ni je oche property ni. Akabo je ma akọ okweje me. Ni English kabo je akọ okweje me. Lo na kabo je akọ okweje me ke ogbowe beje okabo ke ni ho obi. Money ke ni ha bo je le no e farm go je. So that principle was applied in that case. That you cannot give what you don't have.
Right.
So Gbawe lost that case of oblogo based on what? This that rule.
That's right.
That area, a cover Makati il So the basic question is that Mokoni Beshpon go no,
yeah. Yeah.
How do you then cross and get land at the other side of the road?
Of the road, that's right. That's right.
So the Trinity is not needed.
It's not needed. You just have to
proof a root of title.
Root of title, right?
Okay. O subject Nii Adote amamene ni akola judgment
yes.
So I think it is what just
but once again akola judgment and that's what the defendants, in this case the Sempe Stool, one of the key things rely on to make their case, and yet the court is not buying it.
Don't could be any surrounding land and no money are declared according to the Akulache judgments.
Actually, yeah.
It was the Alata.
Yeah.
So what is the Alata people doing? Two, the Akulache judgment there, but we was not a party to it.
Dabi.
Good, but we was not a party to it. It was between Nii Alata song. No honey. The court relied more on the justice of all judgment because one, the two parties said, but we can simply were all a party to that suit.
Yes.
So something that you're a party to it, a decision in it, you'll be bound by it.
Right. And of an animal bibo in Shani a review your Supreme Court and the opportunity by ni obanye or provide further nibi about make case better. Hello, that's it. They are just going to go over what has been done previously.
Okay, appeal, like as they say, is by way of what? Rehearing. No, what is there is no need file about run copies of it.
Right.
Ni about bundle. Na keba court koni court weigh the evidence no keba and ekolashi no ko yemi lo. Ni mostly ke appeal ke na kanibi I use for precedent wa denche. The law says statute precedent. But you know I rely on most. Yes, a review. No ekole no legal no kwete no ejeme ona ete no court below.
Right.
Then the appeal court, the appellant court will have to what? Revise its notes.
Right.
And see where things went wrong in the what? In the lower court.
That's right.
Lower court. No review anything can happen. And it depends on what? The kind of evidence you submitted to the court.
Right. So if it's rehearing, I'll find a rehearing include or adduce new evidence. Right. So you cannot reintroduce no codon except for what has already been provided. Right. Okay.
Exactly. The owner can look at tomorrow. Of some of the cases has already been reported.
That's right.
So it doesn't mean that you cannot introduce an evidence, which is substantial. Bear in mind, which is substantial.
Right.
Any ordinary evidence I call papers come no call can back. No, here name at the time of the trial. Where were you?
So once again, people questioned it earlier, but if yes, they were not able to prove they have title to Akukor Foto land, say But in your opinion, why is Lee saying now making ADC? Hello, ADB. Why was it not enough? Because to Mobeno, you cannot give what you don't have. But these people were able to lease a land to a whole. You understand what I'm saying? Why was it not enough? And Lee say mokwe challenge ko. I don't think ake mokwe challenge ake nakan shipon wa no mi Sempe me jushi. I'm a jushi na me at least moko. It's never there's not a case challenging that for all these years.
Normally, when a case is meant by being challenged, it's in different food.
Okay.
Challenge in the sense, actually, at the time, I grant Lee say, moko raise no about it. Or two time ni or lead evidence in court there. The other side there.
Right.
The other side there about challenge.
Okay.
With the evidence you are providing in court.
So which was what was done this time around?
Which was what was no one actually le court ADC can be but the most important thing root of title because chemenyo no
that's right
chemenyo no no ni chemenyo no definitely some historical events
right.
I know Chon, but if you know, only make on number fight over it. Niwe, don't need domiji. The cases 1916, 1918, waterways, I stopped 1951. They should raise those issues.
Yes.
Raise the
raise the clearly. I raise the yeah. Now, when I mean people actually in the review, these are important substantive Nine na me banya me adduce. Is that an opportunity for them?
Final judgment, then you can get substantial. These are judgments that have been given in the same court.
That's right.
So you can quote them and provide and add those evidence
to it.
Because sometimes I'm a fear submission in court you should file your written submission.
That's
right. You file and quote all those
and
things.
Quote all of those. That's right.
Do you have a copy of this in the provide a copy of non site to aid the court.
Right.
Judgment koni kashini in your submission or state na kan judgment ne kule court be copy. E ba nyene request no ke copy aba.
Right.
No, ina na kan submission say
ebemi nkla ebemi anyways okay, now Nii Sempe may release a statement and I wanted to ask you Keji Tomoboni Sanene clearly Sempe may file for review and the execution in your Supreme Court the judgment tell me Alphabet that be a go ahead, i.e. onake kumo any be, even though we can say ake case finally agbekuna ani amebanya ni amefe na kai ni a file for a review of that particular decision ni ame rely on no na make kumo ni be.
The rule is that appeal per se does not constitute a stay. Appeal per se. The fact that you file appeal does not mean that other party in a judgment any execute judgment. You must file the appeal and also file a stay of execution.
That's right.
And even stay of execution you file or the appeal does not automatically stop the enforcement of the court of the lower court judgment. No, call file appeal it doesn't enough. Stay of execution call file still is not even enough. So court a move order. She be stay abortwe I relax because only abanyana femini I grant I relax. Done it too. That exception ni court by grant of execution. Bona feni, for instance, in this case na review ne ona tu ka kuma bi ane na te review na ka explain I overturn the decision I create a lot of damages.
Yeah.
Na kuma is irreparable.
Yep.
Well, normally a grant or stay ni aka protect the status quo of the land.
That's right.
Oni shiko ahiboni eyo no kashi boni abagbe sande na. No kagbe na ka ya akumole we twinjole.
That's right.
Well, the fact that I file appeal in itself is not a stay.
Ishe, thank you so much, Alaji. In your 9 pages, go be so far. Call you around there, but stay more around. No booming into it. In promise, ni sempiake makandi male. Can aning kandi. And what kind of can case kodi worry kewak bina ni waba back to you. Ni wakwake minijino ni nobanye ifi kewa.
Very well.
To find you. Thank you so much. All right. So I'll get back to you. Right. So Chemekanyeme. There you go with legal expert. Benyele Nintete TV. Kebale neke sanjinele. Kawa reach out to Alaji no Boli. Eke opinion baba. So nye tomobeni nye meninye kawa ye be show me during the course of the show. Ni sempe send you judgment koni wakandi. You understand what I'm saying? So nya wakandia. Alaji yageme ebo watweni wakwake ani no bawa in this case lo ke amefe ameyake ni ne lo. So let's see. So this was another case involving Sempe versus the Adam family. Nakae no. You understand what I'm saying? So let's open it up. Ni wabi. Okay. Yeah, me 1 second. All right. Chemega nyame. Boli. Yawa. Jani femo. Tumobeni nko bodane. Kiyamokoni. Okiyamokoni. Dabi. Agenka kelang. Age kiyamoko. Ni leun ekeyamoko. Kiyamoko ni leun ekeyamoko. So it's only 9 pages. Nii Adote Otinto can have me. So what bina no if let's read it. Ni wakwake iba share light in some of the in the onabonicho iba fe no go kewa this particular case ne lo okay ani igbelemo mfe ni na be. I think I should do it this way. It's unbelievable. Once again, there were fair working kaseni ye chemega nyeme. Ni you da ne nke bo age wo fe won kaseni enefe ni kase money. Boni shishi. Enefe ni kase money. O meni wo yo man say especially mi twaje me ko ke o tawo shipon ni o ni o tawo ni tumoni bi ne ni nke bo efe abotem yodugba no na ko ye man say Appellate will be able to help you. Bona. Appellate will be able to help you. Bona boni ni yo. So Appellate over ne ime ni bi e kome ka chomo mi kome ni shipon ka ni wakwe bona. So mini case ne. Okay, this was in 19th April 2012. Okay, let's see. Appellate shikwanji engme kome ka ni tete TV bi boli neke trouble neke margin trouble ne amega botemi onu shishi so ami town say ko chomo mi town say ko ni no fe no afi fan kewo yue ni wa yue lojugba once again abani Appellate ke abo e ba no na moni nye title abo indenture pe na ba shigbo ake o ya gbo gbele dabi aba no face wake o ba na ke money on shipon there you go. Appellate ke efe no tawo e ko ye o wane just reach out to me. Bona reach out to me. Appellate will do due diligence for you. Abo indenture pe ni be ake bo wajeme dabi e ba face sure. Appellate ba face sure ake ke o e shipon o he money lele yegbe no ye wale ne sani na kan shipon e won habo awa for those of you who don't know ayeleche oh Akuje yeah me 1 second Akuje Akuje ofane anima kane nyenoni ni sempe ke awo keke nkebo eba no onu Akuje ofane ke onu ofane ami thumbs up ni mana age onu mi onu ofane ami ama kane no ni sempe ke awo nye keke wokeba no right. Thank you Akuje. Right, so tomaboni nkobo efe me kome ye ni tete TV family emi ni ayeleche ewa me ni amehe shikonji me kome ni they have issues with even amewojinke ni bi ayeleche ewa me ke nye efe eba kebo ayeshka the ayeleche dabi ke oshka yo de eba nye efe kebo ake opele noko ne enye tuni ye dabi ke ayeleche ke pay mommy ne ken be ebanye fe eba kebo anukwale ke nye efe eba kebo ake nye ma fe ona boni ni yo ke nye efe eba kebo so far ke okwemi and we have testimonies ye ni tete TV family ewa me ni ayeshipon ye Ghana ni with no issues with no problems whatsoever so far keji bon obasumo ni oyeshipon ni sanibeye boli ayeleche ye bie nyenu ayeleche ida benyeli nyeli ole is boli squad there fita squad there so nyani wakania noni ni sempe ke hawo nye bona keke wo kwe noni baje mi ba kaya iko ami 1 second I'll be right back. Let's go Ashbeni Bogatanga Baligatanga baby Baligatanga baby oh no your body they make us sell Baligatanga baby oh hey Baligatanga baby oh no your body they make us sell Baligatanga baby oh right chameka nyame nye yiwala don wakuse woba so nye ni sempe ani woni ne share document na no it will only be right ake woba kande koni ekole no ni etawo ni mambie ale eke mambie ele You understand? So this is another case, I believe, with the same Gbawe Kwate family. Like I said, in Kebwake, I've seen cases where the Supreme Court rule 5-0. I get a review. Some judges say no, come no fit 5-0. No, I'm not. So it is not over until it is over. You understand what I'm saying? Nya what can ya in it to be 9 pages if koni work alaji baba no ka work be na hu bona eke work now obana ke judgment ne jepo 19th April 2012. Okay, once again about our background there so obana Sunday no ni ayo obana alaji ke explain it chon bi ane no ake corner can hear about the background story everything okay before about judge arrive at a decision there. So once again, Korame ni yo jeme drink all the entire court. Many metala no ne presiding many verses. So this is the case. Case say Benjamin Adote Alote Nii Aflan Ochami Adote Nii She. They are the plaintiffs and respondents versus Nii Adam Kwate Kwati defendant. Benyele Alaji Alaji ye Gbawe ni ami you mo fẹ́ mo le Nii Adam Kwate Kwati legit boli Kwate family ni yo Gbawe ame icho. So this is a case between clearly ko pe gbe ni ojo ba na ke Sempe me ke once again Gbawe. So this is another case involving Sempe ke Gbawe. Let's see what this judgment what this case is about. No what judgment any yo me. So, presiding judge, Justice Asari Koran. Okay, let's go. Now, Bebolencha onake a faint few bona. So much struggle with the reading, but bear with me. Let's go. Okay, this is an appeal against the ruling of the High Court, which granted an interlocutory injunction in favor of the plaintiffs/respondents. Respondents for short year after, restraining the defendant slash appellant. Faint in a print chucky. And all other persons, previous assigns, and all other persons interest for the defendant and the Gbawe stool from interfering or in any other way dealing with lands to the west of Accra, which includes the land generally known as Akukor Foto or poultry farm or pig farm. Okay, so this was an appeal court's judgment. Ni onake the case said once again, a call Akukor Foto a printed by Chaki. So man ba ni makani no ba no should but this side the bolen check o screen there no ubanake a little faint. You understand? So let's go on. Ni wakwe noni case ne let's go on. So once again, it was the Sempe Stool kwe plaintiff say ni yo mi e fon na ke Sempe me son ke Nii Adam Kwate Kwati. You saw that. So once again, Sempe versus Gbawe. Ni shikpon sande na you or ye bi Akukor Foto the same Akukor Foto shikpon no sande are you all. So let's go on. In the court below, the respondent's writ of summons was endorsed inter alia for a declaration that the respondents have always been the owners of Akukor Foto or poultry farm lands. A further declaration that the judgment of the High Court presided over by Victor Ofoe. Okay, so once again, so they actually appealed against it. So there is a judgment. So why in the middle of the fatal court say ena Justice Ofoe no kone? Judgment no okay. I mean, that is your appeal. Judgment cover your appeal against Justice Ofoe judgment. So middle of court. I don't know. Was it presented? Did you guys? Alaji, I believe you are still with us, right? Okay. So Akukor Foto ejameno once again. Justice of where Banake no in candy abu a court no care. So there was an appeal. In Lancashire, they appealed it and it was strike out for want of persecution. So what is this? All right, let's go. Let's okay. Obanake printed by Chaki, so Obana le better. No and of no infedame for recovery process. Okay. A summary of the facts in the statement of claim accompanying the writ of summons in the High Court suit number are as follows. The respondents are principal elders of the Sempe Stool, a division of the Paramountcy of Accra. The Sempe Stool is possessed of the allodial interest in a vast tract of land to the west of Accra, which tract is inclusive of Akukor Foto, of the Gbawe Stool, which the subject matter of the suit and through its servants and hirelings has encroached on parts of the said land. It is contended that the occupant of the Sempe Stool initiated proceedings in respect of land in dispute in the High Court in suit number L215/2001 against 4 defendants, including the appellant in this appeal, Nii Adote, head and lawful representative, Gbawe, Accra. The Sempe Stool, Nii Adote Otinto II, after a hearing on the merits of suit number L215/2001, lost the case in a judgment delivered on 11 July 2006. Nii Adote Otinto II appealed against the judgment, but on 5th May 2009, his appeal was struck out on the grounds of non-compliance with the rules of Court of Appeal. So there you are for want of prosecution and now you here. So I guess they took too long before they so nakan time lapse. So okay, interesting. Let's go on. The respondents claim they instituted the instant suit upon which this appeal is based because the occupant of the Sempe Stool, according to them, was unwilling to take steps to protect the land in dispute, which is the property of the Sempe Stool. Want of prosecution. No, tied and farmed on by subjects of the stool, with the stool periodically allocating unoccupied portions of the land to stool subjects and other under customary law and usage. As an example, the respondent cites the grant of a lease of the land by the Sempe Stool to the Agricultural Development Corporation. Once again, right here, in or around 1960. Once again, I'm a bit specific with the year. No one Supreme Court now me provide list 1959 after 59. I mean, I feel 60. There was no initials, so I mean they don't even know if it is legit or not. And the acknowledgement. Let's go up. Ote spoon too much. And the acknowledgement by the lessee of the Sempe Stool's title during the term of the lease. The respondents also state that between 1948 and 1963, the Sempe Stool asserted its title to the land in dispute. In the case of Nii, I'm in quote, but you know all of these cases, and I'm in quote, no. Nii Adote Otinto versus J.A. Kwe, suit number 22/1948, consolidated, in which the specific reliefs claimed were, inter alia, for a declaration of title and an order of perpetual injunction. So, I mean, case one of the claims, one of the reliefs now in CK I declare title and a perpetual injunction I stop Mofemo from encroaching on the land. In the said suit, the trial judge in particular found that the poultry farm or Akukor Foto land has been leased by the Sempe Stool to the ADC, and that the Sempe Stool had within living memory uninterruptedly been in occupation of the land in dispute, either directly or through its stool subjects, lessees or assigns. This judgment of the trial judge, the respondents claimed, was confirmed by the Court of Appeals in Nii Adote Otinto versus J.A. Kwe, Civil Appeal number 50/66, which definitively established in detail all issues of title to the land in dispute, of which the poultry farm land forms part. The respondents observed that during the protracted and well-publicized litigation, the Gbawe family or stood idly by, in consequence of which title to the Akukor Foto land has already been settled, and any judgment by a lower court to the contrary is therefore void and given per incurium. Explain what per incurium in Chombo. Ni try to follow precedent, follow a binding legal statute. In the circumstances, the respondents contend the judgment of Ofoi, Judge Ofoi ni ake ataye. So apparently it was that. What is anyways? Something happened here. Your case name. Let's see. As it then was in suit number L215/2001. Maybe I'm getting it wrong. Alaji, I explain that. Dated the 11th day of July 2006, was void and of no effect. Because that's what they are saying. Because of all these, all the way up to the appellate court, now Rulombo, of which this poultry farm, Akukor Foto, form part of Nakan decision. There's no any judge of way chakiole. Among men in Yakapano. Kalajiba Mabile. Okay, so it was pending the pendency of the suit number SOL24/2010 in the High Court that the respondents applied for an order of interlocutory injunction against the appellant in respect of the land in dispute, which application was granted on the 10th day 20 of June 2010. Okay, let's go on. It is against the grant of the interlocutory injunction that this appeal has been taken by the appellant. The grounds of appeal being 3-3-1. The respondents not having pleaded fraud in their statement of claim and not having given particulars of fraud in the statement of claim, the learned trial judge erred in law in basing his ruling on allegations of fraud in the respondent's supplementary affidavit. Okay. The trial judge was wrong in granting the application for interlocutory injunction since the Honorable Court had no jurisdiction to entertain the suit. Because there was already another one going on. Because it was pending that case, interlocutory injunction from another judge here. Once again, legal gymnastics. So that is why the Sempe Stool is saying, judge conclude here, they cover this same portion of land there. If your judge conclude take or up the same case, they grant or interlocutory injunction against or okay, I'm not a lawyer, I don't pretend to be one. That is why we have Alaji. He will come on the line. Let the law school and me yakueko. Let's go on. The trial judge was wrong in granting the application for interlocutory injunction since the Honorable Court had no jurisdiction to entertain the suit. The trial judge failed to consider or failed adequately to consider the appellant's case, materials placed before the Honorable Court in opposition to the respondent's motion for interlocutory injunction. The learned trial judge misdirected himself when he stated that on the basis of the pleadings and affidavit together with the exhibits, I'm of the view that a prima facie case of right to be protected exists. I therefore grant the application for interlocutory injunction as irreparable damage may be caused to the applicants should this application be refused and in the long run win the case when it is heard on its merits. 5. No cogent/relevant evidence was placed before the trial judge to warrant the grant of the respondent's application for interlocutory injunction. The ruling was against the weight. Oh, too far. Too far. The ruling was against the weight of evidence before the trial court. Number 7, the case of Yaudwade crab and all other materials relied on by the trial judge in his rulings were all agitated before the trial court. Judge Ofwe, the said materials cannot form the basis of a fresh trial before his lordship, Mr. Justice Okran, to warrant a grant of respondent's motion for interlocutory injunction in the matter. So the case was before somebody else, and then oh, okay. So this appeal was not necessarily against Noni Judge Ofwe, but it was against the interlocutory injunction. Nii Alhaji Mensiki. So anyway, let's go on. I am not a lawyer. Once again, I keep repeating it. There is a reason I ask school for a specialty. You understand what I'm saying? So you need people with that specialty. And I'm glad we have Alhaji. Anytime she comes will reach out to le will reach out to le. He's always there to help us. You understand what I'm saying? Because these legal issues, they are complex. English is not law. God no bluffo, no shishu wa, no can your bluffo wa, to my boning can your name. It does not make you a lawyer. You understand what I'm saying? Bluffo law. Let's go on. Okay. The learned trial court misdirected himself when he stated that there is evidence in exhibit NAQQ 2, which was exhibited by the appellant, that the occupant of the Sempe Stool wanted income from the stool's land to be paid into her daughter's name, and this was refused. Oh, okay. This is not enough reason to make occupants of the stool to punish his subjects by refusing to protect the stool's interest? Why did he not prosecute the appeal if he had the interest of the stool at heart? Nii Adote Mr. Diplomat. Okay, page kaka will be your account to me. So this is where any want of prosecution by me. This is the case. Nii Adote Otinto make na can case like a predecessor because of nekindi bi come war a shina can case a machine. You understand what I'm saying? So Nii Adote Otinto be an take over the case no na different on abonincho so if you don't know I get bear wo me on a simple no pa come but clearly new king ebano so ni new king ebano ebakweni afi na emefe. Number 9, the learned trial judge misdirected himself when he stated that on the basis of the pleadings and affidavits together with the exhibits, I'm of the view that a prima facie case of a right to be protected exists. I therefore grant the application for interlocutory injunction as irreparable damage may be caused to the applicant should this application be refused and in the long run win the case when it is heard on its merit. Number 10, the learned judge erred in law when he failed to consider whether it is just and convenient to grant the injunction by interlocutory order. Before considering the merits of the appeal as a whole, I must observe that some of the grounds of appeal offend against the rules of this court, with particular reference to rules 8.5 and C of the Court of Appeals Rule 1997, CI 19, which provides as follows. 8.5. The grounds of appeal shall set out concisely and under distinct heads the grounds upon which the appellant intends to rely at the hearing of the appeal without any argument or narrative, and shall be numbered consecutively. 8. No ground which is general in terms or which discloses no reasonable ground of appeal shall be permitted, except the general ground that the judgment is against the weight of the evidence, and any ground of appeal or any part of the appeal which is not permitted under this rule may be struck out by the court of its own motion or on application by the respondent. Looking at grounds 3, 4, 5, 6, 5, 7, 8, and 9, of the grounds of appeal, it appeared that those grounds are not in conformity with rules 8.5 and 8.6 of CI 19. The said grounds, as formulated, are in the nature of a narrative and are therefore prolix, argumentative, and general in the manner they have been constructed. Grounds 3.4 and 3.9 of the grounds of appeal are also repetitive as they relate to the same objection as to misdirection on the part of the learned trial judge. Quite clearly, all the objectionable grounds of appeal referred to herein be subsumed under the ground of appeal number 3.6, which says the ruling was against the weight of evidence before the trial court, and accordingly, those grounds are struck out by virtue of Rule 8.6 of C119. Okay. It is also pertinent to observe that the respondents in this appeal failed or neglected to file written submissions, even though the registrar of this court, in compliance with Rule 23, with Rule 23 of CI 19, caused copies of the appellant's written submissions to be served on the respondents. So, noni onani wakandi appellant said, Sempe man, respondent said, Gbawe be here. So that's what you are hearing in this particular case. Ni wakandi kani a confusable. The grave man of the appellant's ground of appeal was based on an allegation of fraud made in the supplementary affidavits of the respondents. The appellants argued that the respondents, not having pleaded fraud in their writ and statement of claim, the learned trial judge erred in law in basing his ruling on the allegations of fraud in the respondents' affidavit. There were two passages in the learned trial judge's ruling on the issue of fraud that did not sit well with the appellant. The first observation by the trial judge reads, 1 second. So, mina laji Adam Kwate ke jeme. Okay. The first observation by the trial judge. Okay. So Alaji ke ni jeme no shishi. Okay. The next issue raised by the respondent's counsel is that this court has no jurisdiction to entertain the plaintiff's suits. Right. So you heard it. Nakano ame because case ka mokonklo yin. So amenkake Alaji esa ani ne case ba court po let's go again. The plaintiffs / applicants in this suit claims a direction that the judgment of Victor Ofoe, as it then was, is void and of no effect. In the supplementary affidavit, the applicants also mentioned fraud. If these are proved at the hearing, this court would have the jurisdiction to set aside the said judgment. If the statement of claim did not give particulars of fraud, as has been done in the affidavit, an amendment may correct it since the hearing has not commenced. Okay. Can follow me? Obanage nibi ekome ene share light on nibi ekome ni wakande ye both the Supreme Court and the Appellate Court. So respondents say Nii Otinto Sempe bi onukpa meji respondents say I mean keke nibi Ojogba. Okay. The appellant censured this finding on the ground that it is not the function of a trial judge to make a case for a party litigant who was before his court. Again, the appellant, anytime in this particular thing, again, criticized another finding by the trial judge that a court of coordinate jurisdiction could set aside a judgment of another court that was void or obtained by fraud, as no jurisdiction was conferred on one jurisdiction of the High Court to declare the judgment of another division of the High Court void and of no effect and or given per incurium. The appellant further argued that the trial judge had no jurisdiction to entertain the suit instituted by the respondents and was therefore wrong in granting the respondents' application for interlocutory injunction. This ground of appeal, the appellant contended, was based on the fact that the respondent suit number SOL24/2010 relates to matters or issues raised by the occupant of the Sempe Stool in suit number L215/2001. The Nii Adote case referred to by the respondents in suit number SOL24/2010 was also introduced by the Sempe Stool in suit number L215/2001, and witnesses of the Sempe Stool gave evidence on the Nii Adote case as pleaded by the appellant in his statement of defense at pages 78 to 81 of the record of this appeal. The appellant also states that the parameters of the land claimed by the respondents herein were the same as those set out by the Sempe Stool in suit number L215/2001, which the Sempe Stool lost anyway, and it was false and dishonest on the part of the respondents to declare that they have sued the appellant because Sempe Stool property was in danger of being lost or account of inaction by the stool occupant who was unwilling to take steps to protect the land in dispute, the property of the Sempe Stool. The appellant insisted that the judgment of Judge Ofwe, as it then was, so no jinoni akobo, so Sani ya okay, aware. Because Justice Ofwe ne onaga a case I ya appeals court take neke no name no okay. The appellant insisted that the judgment of Justice Ofwe, as it then was, dated 11 July 2006 in suit number L215/2001 was not contrary to the judgment in the Nii Adote case, and as between the Sempe Stool and the appellant, the action instituted by the respondent in suit number SOL24/2010 was res judicata, and the issue of Akukor Foto land cannot be relitigated. Kaka res judicata ben nyelomo sanena yomo agbena at decide final decision na ke homo anya sa na ya na chake ko no ji res judicata konuni ake res judicata. That's what it means. Sane at decide le final yomo mukonye ya ne ba se ba wo ekon ne ba se ba bon sane shishije ekon res judicata. That's what it means. It is said that the grant of an interlocutory injunction is both discretionary and temporary, and proceedings for interlocutory injunctions are usually by motion supported by affidavit without resort to oral testimony or cross-examination. Pending the final resolution of the matters of substance in an action, pending the final resolution of the matters of substance in action, an interlocutory injunction may be granted if the applicant discloses a prima facie case for the purpose of preserving the status quo or putting on hold the circumstances surrounding matters in dispute in the action, as Cadden LJ observed in Preston v. Lack, 1884, ch.d.497 at pages 505 to 506. Of course, in order to entitle the plaintiff to an interlocutory injunction, though the court is not called upon to decide finally on the rights of the parties, it is necessary that the court should be satisfied that there is a serious question to be tried at the hearing, and that upon the facts before it, there is a probability that the plaintiffs are entitled to a relief. In Cavendish House, Shadowham Limited versus Cavendish, Woodhouse, 1970, RPC 244, the court stated, you start up with a prima facie case. That, of course, is the essential prelude to the granting of interlocutory relief. To succeed in an application for interim injunction, the applicant must show that irreparable damage will result if the relief is not granted. See Attorney General V. Hallett, 1849, 16 M&W 569. Irreparable damage was defined in that case to be one which cannot afterwards be compensated by any decree which the court can pronounce in the result of the case. Other considerations to which the court should advert itself are the balance of convenience and that the plaintiff's claim was not frivolous or vexatious. In other words, that there is a serious question to be tried. See the case of American Cinnamon Company Limited versus Ethicon Limited, 1975, which decided that the use of such expressions as a probability, a prima facie, or a strong prima facie in the exercise of a discretionary power to grant an interlocutory injunction leads to confusion, and that once the affidavit evidence showed that there was a serious question to be tried, it becomes necessary that the balance of convenience should be considered. In the instant appeal, the finding of the learned trial judge in the exercise of his discretion to grant interlocutory relief was as follows. On the application for interlocutory injunction, the plaintiffs/applicants have deposed that on the basis of the judgment that they claim to be void, the defendants have been destroying property on the land and exhibited some of the houses they have destroyed and those to be destroyed. The respondent did not deny the destruction but claims that that has been done because of the judgment of Victor Ofoe, since the applicants claim that the Akukor Foto or poultry farm land was part of Nii Adote Crab versus J.A. Kwe case, and that the Supreme Court had affirmed that finding, but the judgment of Victor Ofoe had found that the subject matter in the Nii Adote Crab case did not include Akukor Foto land. And of course, Obana can no etemi. So Nii Adote Crab case, I think I have it somewhere. I probably have to look for it. Ni wafe sure I can lele a cover na kan Akukor Foto land say low. But even if it does, the Supreme Court said okay, that alone did not grant possessory rights to Sempe. That is where they are coming from. So once again, it is incumbent upon Sempe to prove possessory rights. The Akukor Foto lands may have been part of this Nii Adote Crab case, but court it come to a conclusion. Okay, Nakano a grantee possessory rights to Sempe, and that is where I think the thing is. Let's go on. It will be proper to grant the application for interlocutory injunction for the case to be determined on its merits as to whether the Akukor Foto land was covered by the Nii Adote Crab case or not. So Nakano Sempe make okay. Having discovered and isolated the issue to be determined by him, the learned trial judge came to the following conclusion. On the basis of the pleadings and the affidavits together with the exhibits, I am of the view that a prima facie case to be protected exists. I therefore grant the application for interlocutory injunction as irreparable damage may be caused to the applicants should this application be refused and in the long run win the case when it is heard on its merits. The learned trial judge therefore rightly dealt with the principles applicable to the grant of an interlocutory injunction in the exercise of his discretion, namely the consideration of a prima facie case, irreparable damage to the respondents in the event of a refusal of the application, the balance of convenience, and the existence of serious questions to be tried on the merits. I think the grounds of appeal filed by the appellant relate to the merits or substance of the actions yet to be tried by the learned trial judge, and as such, appellant asserted in the statement of defense. The plaintiff's action/suit discloses no reasonable cause of action and is also misconceived. At the appropriate time, defendant would apply to have the entire action and suit dismissed. Again, as stated by Lord Diplock in the American Synod case Supra at 510, it is no part of the of the court's function at this stage of the litigation to try and resolve conflicts of evidence on affidavit as to facts on which claims of either party may ultimately depend, nor to decide difficult questions of law, which call for detailed arguments and mature considerations. Having regard to this statement of the law in the American Cyanide case before, I'm of the view that it is not within the preview of this court in this appeal to set aside the ruling of the learned trial judge on 10 June 2010. In the circumstances, the appeal is dismissed and ruling of the trial judge granting the order of interlocutory injunction upheld. Still, it looks like from what I read, injunction any appeal against the Nii Adote Otinto, they won because in Sempe me no niketi. Yeah, they were there. Okay, so let's see. Am I going to feel ni masa makande jeme ko. Okay. All right. You know what? Alaji is best to speak to this. Alaji Abano. He is the lawyer, not me. Let's bring on Alaji first. You work you at and then walk away. Alaji, what's our beko? Oh yeah, na walada. So
I mean.
Over the none what candidate Akukor Foto. Many you don't know call because and near fame basa feel so over the body expect blame me
my break it down in simple terms, in very simple terms.
Okay.
This is a ruling, not a judgment.
Okay. So caption any your wrong.
Okay.
Any your there was wrong because it was for okay. Over the yano.
No, it is an appeal.
Yes.
From a ruling. Just the first line.
Okay.
Right?
This is an appeal against the ruling. Exactly. All right.
Against a ruling. Mm-hmm. So here in this case, we are talking about a ruling.
Mm-hmm.
And the merit of the ruling was what? Against an interlocutory injunction.
Yes.
So
exactly.
It was rule and a injunction ni appeal court ni no 1 year.
That's right.
It was Sunday muele challenge kashini abakui.
Yeah, that is true. That's right. So Sunday let me tell my real quick on no channel. And the case Sunday can judge conclude na the same Sunday no abanya apply for interlocutory injunction from another judge. Just by way of education, because it appears
normally it is in the same court. Ni hear injunction because a judge cannot stand on its own.
Right.
It must stand on a case, on an existing case. No case he be no kake we are here injunction he conclude.
Right.
Normally, what happens is that equally judge anybody preside on it. Equally vacation judge ko allow let's say judge ko ni ona equally judge ko back e bar court ona another judge e preside over e assist no ba it will happen that way.
That's right.
See akesani e kan e conclude e ka to a injunction ni court sanogobe court e kwa injunction it's never done. It must stand on the case.
That's right. Because that's one of the things that you the case was in front of a different judge. Now my interlocutory injunction a different judge. Exactly. So that was one of the points that I raised and I wanted to see and then I know it's possible. So over the channel with your anyway.
No, not me just so for judgment ruling no clear.
That's right.
Okay, one at the appeal. Appeal when I dismiss appeal.
That's right.
Who got to dismiss appeal. Lose
Yes,
there's a full judgment there. Only lose opportunity.
Yeah.
She Nii Otinto 40 because jail money start case.
The
yeah. Predecessor money
start case.
Ebola blow.
Yeah.
When he is facing the consequences.
Yeah.
Because how can you sell a land like a shikaba will be account?
Will be account to me. Yeah, it's ridiculous. I mean,
Ona, ake wo account mi lenke. Any person na ba court. Court na pay, wa pay.
Yeah.
Any me friend ba je court ni ake ona is unhealthy.
Yeah.
Ona, no a predecessor money. Ebola blow. No mean time you in simple terms ya keshi. Just a full judgment there. It is a high court judgment.
That's right.
And at the same time, there's an appeal court judgment. Niji be appeal na tena overturn. I mean, abstract out there. In itself, it's a judgment.
It's a judgment, right?
In itself, any ruling no, the only weight that this ruling will carry is for interlocutory injunction. Ruling that was not granted.
That was not granted, right? Right.
That's it. In simple terms.
That's right. One more thing. The other question, the issue of this Nii Adote crab case and Jeff Quay being res judicata, what do you make of it? Because this is truly a settled no cover portions of the land any Supreme Court reaffirm why is it being litigated again? Because I'm a raising like I won't know
when a matter is being raised, plead for rest, or you are pleading for estupel. And when you plead for estupel per rem, in this case, one I be was the parties to the case identical.
Okay.
They must be the same. Let's say they must be the same or identical. The parties. No one. Sempe Gbawe was in the other matter. It doesn't matter who was it. Isane na ye Gbawe ile ni Sempe le Trinity Stool le German at that time. Ona. No abakwa ke ani we do have something like that in the past. And two, no in the past. Is it the same thing occurring? So the subject matter must be what? Must also be the same or identical.
Right.
Then you complete rest. Okay, she's sanena yomu asa I won't know na yi.
But don't you think they have a case? Because Keji wanyo raise rest yeah na kind of me. Akukor Foto land say was part of the Nii Adote crab case. Even though Tumobeno Chong party say may be different because Gbawe Bemi at the time Tumobeno Chong.
Exactly. So that's what I said earlier on.
Right. So because I'm a Bemi here, okay, got you.
He was not a party to that suit.
That's right.
No, why don't you bring in cases that you were a party to?
That's right.
No, be shemo na nyene ake 1916 ke na kanibia ya. To proni ke wa ke shi. Na te ni English ata ya fight ye. Akwa je ke Sempe ke na kan me amechuku. English ake e ya yesane ye. E be capacity. De you ba shi ayi le shimo na le capacity conclo. No anjit na kan time ake Trinity Stool anity. Na here Jamestown 3 quarter se fe nku.
Right.
Spengmene Sempe moral grounds.
Yeah.
Ni ebayende plead na kan judgment jin.
Right.
Chin ye na kan. To the extent na 1955 judgment ni ji waterways extension Sempe a lose ye mi.
Right.
I lose ye because le no ebono occasion na kan je ochuko ma ke bayi. When I came some years ago in 1951. In 1955 e bia no bo ke je hu bu no.
Anyways, Alaji.
Another issue ko huni inaji. Akesani Trinity Stool sana me back ni amba fe ko me. Mini be wa ata we ko nkeba.
That's right.
Come on. Yes, me so na jaka fe ko be je ameka me fe ko. We awo Trinity Stool say no mi ba no ka take court ni bia ne Trinity Stool a wuni na mushpa akaba we di. Akaba Sempe.
Tago gabas.
Alo akumaji.
Abase gabaja.
Abaja. Na ho fe on we na mo tui mama no. O wa shira ni Sempe di. Janyamula yekpe. Janyamula yekpe.
Oh man,
structure say I said to you, the structures are there. All you need is to get the relevant document,
right?
And the relevant people, the relevant people.
Yeah.
In English alata yo, in English alata nini.
Yeah.
English alata what feko da. What feko in 1951.
Yeah.
What feko in 1916. What feko in 1918. And they get akwene na cho in James. I think Salona Akolache judgment 1990 no.
1990
Supreme Court no.
Okay.
Yes, Supreme Court no. Sanona.
I'm a quack. That been no. Supreme Court no. In the original.
My forward.
You in the original Akolache judgment. Supreme Court no.
No, me no nike Akolache. Akolache. I call to Supreme Court no.
Right.
Because the Supreme Court is the final decision.
Yeah.
Maybe you know me. Ni Heokoni, I think it was yesterday. Ni o state principle. Okay, the custom of the Ga tribe is that a land which had been exclusively used by inhabitants of a particular quota belong exclusively to that quota.
Yeah.
This was the principle now I use now get tau
That's right.
Yohani Wagan was sponsor near Tumo Ashanteme. Be Gamanche Shishi. No Gamanche Nyena authority or Spogiano.
That's right.
Because of the principle, it like a Gamanche Poya Fandoku those days say, Eke Wakuna Waka who 1 million yato be or who be a what tata. Judgment about out Tagash Lele. Me Amamayo, Amamenin. One minute a fight a bay to commit only by never dumoshi. It had game. Na kake a capacity con challenge noko. Let's check about no about anything if I never touch but you could from near home.
That's right.
What about about Buku? Yes, I need no you need dance so I didn't lay Appellate piano. Obana many men back ameno.
A man Batishi, that's right.
About the Shaole. I can go on. Yeah. You know ni about Choni Wule. About Chole Energy, Crapping Goja. Energy. A Choniba Wulega. About Chole session. Nina Fule about Chon Jemmy. Gamemino of your here.
If I could check, yes, Sunday Bass money. I could check over to you.
Yo, Nii Adote Otinto. Modern ni simple nche ike nke wakashi modern ogbula no fia no mi kecho mambi enu no ni fia no ete no ke okwa no ni ete no ibi to mo aba yebo ni wa damebe ke yebo ni wa ora ni ke ayebo ni wa pe ke ayebo ni wa ni yiwa na yebo bo ye ya wa pe be ay no ay onu ko yodi ora shi ni enu kan ni ke je fe ogbe ko na wo aba agbe na mo nshi ke okwe many things of Shiponi Kashefe, Sempe Shiponi. Yeah, ni Sempe ke Judicial lata. Be olakashi woye bond ko kawote. Sempe Shipo ye Judicial lata mi. Judicial lata Shipo ye Sempe mi. Nwani nekegbe mene ami fio ekome bonafe oya komene Shipo. Sani Sempe abafanyi sani ko akọ Sempe Stool Judicial atawon abafanyi
ya akuje na kan Trinity edwa eche
no traga shi no memi yere ku kemba onu shi no traga shi boni ni shi kamo yo oji wo kemme kume chakpa ni nakashi pon kabata bia na mi nkabo fe wole akeshi Sempe ni ke ha adatabie na mekono because sempe eha anatabi ashpo na mekono anatabi hu eha sempe shpo na mekono alole
dabi be jo kemi
yes onake shpo je ko meka Abote mi awo obodo ba le se ake glacier anatabi anoni onake shi ayashpo je ko sempe no mi obodo ba le se abake sponi come glacier anatabi anomi ke oyakwemi awo ake sempe bia ameyemi.
Because at the time, once again, the Trinity and you were earlier, Bona. The Trinity you were.
Yes. No track. Meneke enoha ni ekono. Menauke enoha ni ekono. Odubishi. When you have a sure bond. Ko ye shipo ni ya no ani ke ebalena kaye o kasimpe ke English ke akuma ye ko mefemo ne ka metene onyo ko abishpo keke because wo fe ko beni
that's right
she the way ni e abaleni mi blamo e aba ni meneke waje wo e kajemi wache denche wache Nii Adote Otinto e ba feel clear akeshi English bi je wo nyeme je ame no hu e affect le big time e shako eko e shako 2 years onumeshi
yeah
wo ne kani bi na fe e affect ndi sempe she no ni pebi to ma wie pe ja keshi she po ni yo je me aye hinwa na keko spo ni no ne woni aye hinwa aji bia na neshi alata ni danso je inside dem we mi ke bodoko anukwale bene ba se ko ni sempe ke danso masane ne mi ba fini danso se mi ba ke nu mo dabi je ra kani meneke e ashe ko mi to ma ke ni danso wa ke shi nke ka akoda ka mi fun e no ke wo mi because una no ni ya no fe danso ma ke ni danso bi e amefi Gbawe bi ase mi ke bonoko sempe una ke one
you think I get danso man fi Gbawe bi ase that be danso man make Gbawe sanji and baba o agbego na ye court lo there is no way ni danso ba fi Gbawe bi ase no way
inka ke ni danso ni de over able to inka ke ni danso get danso ma bi e amefi Gbawe bi ase.
No, me come it's very difficult for me to accept that because danso man bi I make Gbawe sanji and baba o ye court.
It very difficult right now. She later oba no she because no ni okane fe koroni ni sempe ke said the boy ni track she pon lenche she pon at the court ni ajeji ni akeha no chomo asa akeba another no cheko onumushi ni agbene bio eko shakesi noche ni akiale first time mini badi achaki ni asaka bara aroda noche ni agbene bio ko shaki nakata mini akera government na akera government aka kafe family na me ni ke ba sempe bi ni ke ha wo nakata me fe kai Gbawe bi ano mi no nakata me fe amebana ba challenge because ni sempe ke akera follow apeshka ame Nii Adote na gas boy wakati na kata me fe je ba no ye onumushi ni mene asa a change the same thing e kwa ke the ownership jail no shi Gbawe no ni at the court meneye ni jete wo fe won to ejola ba ni sempe bola keke if you know here mba call
that's right
she this is pay a chance ni banye can this pay me here ni na can go na gd but in blue money your but a capacity anyway like a capacity e bagda mo fo le na so like capacity
like a capacity e baga
yes you be money like a capacity e ba e wo kaji enye use like a capacity ne ni hiwa ni aye le yes MPF ni ba je ka pona ka ni because numo hia ni bi ba ka bonoko Como ona ke no okane ne ke nye fe ona ke no na ese ni bo no another no ko kwa de no because Nii Adote bo hu e na hu ekeje me ham ni eye o wo ska ke brother no ni Nii Adote bo ke ha wo ji ni yo kachi e besempe no ni kachi kwata bia ne Nii Adote bo eke ha ke si yesempe gba mi le ke ha ni le wo ska de ke brother e besempe wo ji ami right now when ni sempe bia ne e ba fight for the can be na fair because it's a body Gbawe be about corner me okay the Afabita jo it's the same thing
right
it is the same thing
right
it's the same thing because kaji Nii Adote bo e ba ho ke ke amoko ni e ska de ke brother nta ke e besempe wo ji ami the same thing Gbawe be about ko the other me okay Afabita but Afabita eke Gbawe bi osade o ni sempe sadi issue Gbawe bi ojuba that so that ni sempe
be ke se no anye mi
ka focus Afabita too much focus more money ho shipo ha ke Afabita jo whatever
no you
then ho shipo ha me amesani ni sempe e focus ya me no
yeah
because kaji if a thing ni focus the ke Afabita no whatever at me but many ho
Gbawe bi ani ho shipon no ni bi eyemi so Sunday again Afabita pa Gbawe bi
ni sempe e ka focus here Afabita because Gbawe bi ani ho shipon ke ale no because I believe many ka you stand big time what about you
Amabi Alaji ni
yo
Alaji and ofane ani thank you ofane abache ofane ani sempe banye institute another suit just against the Gbawe stool pay yeah the same no the same place no none of it does it not cover everything
if I say me akeshi any Gbawe eko ka waji ni afan e bia na ji Akukor Foto
right
in particular because jenji ni concern no ni sempe wa adenche ni ke okwe I come hu le hu oba na ke gen no ji focus area Akukor Foto no ji the focus area wo keji one we start another case in the high court what discuss ni no
right
multiplicity of suits and the come here no one I feel consolidation no court on a case no na get consolidated suits two say ni sempe me basane emi ake sempe
right
je ame list me na me list mo ame ha ni te sane emi si ame wo me te eko
yeah
ame counter claim once no counter claim it will not go no kesane te court no
that's right
je ga we te court pe ni chu akeshi o te court she court te court we no no actually counter claim no sani o counter claim but when you prove no the burden of proof but we
no yeah
no proof yes no proof case yeah e wo ke I start kon afresh especially ni sempe ya start e ba fi ahun to si ona ke no ni ehin aji ni masumo kwa ke shi ka aye ne ke sanji all the three stools should come in it mo fe mo wa play interest me
I think big point wa denje
because Gbawe bi amaka ebonoko 1916 ka ya le enyo ni boy court ticket
court yep
ni boy court TR court am enyo fa bati
yep
na ka ya le no mi no won le se ka ya onye we yete onye we ya
yeah
ki man so chon ewo abaka ya ni ya ye ni ekwe ya no ye bi no ba o mebu
yes
ya ye be wo mebu ke te ni alusu be wo kele ne ye chewo wo ni wo no ni Where are you work with?
That's right.
Son of me, where you go?
Wanyamino alaye yu akese pesa ni sempe efe shu akese neke share wujie tene ni ji English alatake akumaye sani put am fair together.
No, alaji you she jia get to have no put together. Naga together put.
There are cases pending in courts. Near ye and can jeme always yomoku akeko aishpon je indenture person no afi search no na ke money ha abue le no ni lo
yeah
oti Akukor Foto over the past 10 years funny things went on in the lands commission in anyema do platform no matter lands commission she no ni technology bi many hpon jamba agbabo amba ke bra keke ya fi search mene gbe ni oje wo se ke te kun egbe chaki
yeah
moko ayo spon e feel benefit fe no ba gbe na be ne ba ya ke na akumaje bi akumi ha Gbawe bi ye ame win judgment na kan ke te akumaje be no ba ya sempe le take over the lands commission ona no as an investor ko ne ko ne Kenya no to ba fi ten no mo ba trust
yeah
because mene ke mi no no saji e fe ke o mo no nu aka isande ho no la ke bombo no ni ya no fight bo yete fe ni ha wo ya ka me no na ga be pi won ke mo ko beti e expect ake mo ko be chen wa ba le nya ake gba ake ba no ba 5
right
yeah
ke de ya le nche nwe na ke ko to ya wo ke ba enwe na e ko to ku emi ko
bele we ya ni claim le pe
ya ni claim he man bi so na get to no yu she po je fe wo ke wo sempe ke wo alatadi
thank you
see the fact that okay no go wo boko de hu onyo he edi o ha le egbe ehun eko ekeme kuma ehino na kan ni bia na efe onyo he edi don no ni me na alata me hu aka wo amede sempe ke akuma jamanya me hi
amenya me ni one thing I do je alata ni ba fi o se bo ga alata hun ekelenfa
once ni ake ha le ni ba fi o se po leche na po gwa wa kele no do ka o question pe de ken sempe yen he ko metumo mpoase una kolebu salvation mamprobi methodist presby kemba freedom befe sempe ni amini ni alata hun hie kolegono una eyen choko etechemu plaza John Kobli ke ehewo aklowa
yeah
ehewo aklowa no ngbeje ehewo aklowa John Kobli ngbeje ehewo aklowa sani wa na ke bi eje aklowa na chon no me fe English alata ni no ona ko she bi ene padi ne ma school ne ye Zongo Junction ne Lantemus Road Great Lantemus here road any ken here o senkwe menso tabi school I mean eso mo ni o face flamingo ken ya Russia ona eje na kan any traffic light yo menso tabi je hu kete kashi ya shukura jona be na church
na kanu
Sukura yeah
oni de jofe akumaje shponi kaneshi shponi ni chobo boundary enwene oni de jofe kan akumaje bi anini boni akola chejale nko bu
yeah
na kan stretch obekugbe Trinity Stool
amamenoni right
she na kan time Trinity Stool efe grant ehamoku omo
okay
no grant any Trinity Stool efe akola ka that grant is still in existence wo na kan mo na ke ha mo le hun le no ke o share radio good here to Kolebu say ahun ka jopo mochi road e no wona ke be Kolebu eji no jino ni sempe me amama he compensation ke o share radio good here Ona. No Ogbayo Obeku. No Oya Otea no Bagbakaya banana in road there no. All right, if etanoni actually latte bi okoshie. Jingmembe
right.
Ni inke akeha na kai me. Ko chono no ya banana in Obeku gbefe ye ni ake asamajan sport eh. Na kan stretch fe Sempe manini. That is how Akolache eja na kan shpon eha. No bana kan road there e ya hun ya meet of gota ni kan shukura gota. Nga shukura bien ya ko ba ho banana yin crack ya down. No from there ya danso maniami. Ni according to the danso le hu e mini Jamestown le hu eke shpon ha e papa. Eji ni danso. Because I can declare me Jamestown land, the job and its environs.
And its environs.
Yeah.
Le hu e kola ke je ake hanle. No to be ni inwia ke impoase egbe, kolebu Salvation, Methodist, Presby, Freedom, na ka je egbe fe Sempe amamenin. Pe Akolache,
yeah. Yeah. Anyways,
so that's
Ofane, I have a check question, Babibo.
Ofane, question pending be or pay. No ni mina, yeah. Kaji ni Sempe domoshi, ni ekeni bi ba, ujogba, ni domoshi akashi efficient, and ebanya winning, alo winning.
So be ni inwia kesi se come court mo. Ye na kan je be no. Others too say Ameana ma join. If possible, le hu ya na join.
Yeah, okay.
Because already that case is pending.
Yeah.
Mo friend mo ya na join na kan cases in your court. That will be the solution.
Right.
There is this case ni mene church Gbawe bi ona. Boni amefena make a register shpon. Ame ahe mandemos. In the show aka membo mi to ni bi e ko me ko won wie abe ho ame complaint the paper
can. That's right. Na kind of.
Ame ahe mandemos. Mandemos je na ma ahe ame polo me manu ma ke page ame polo jogba.
Thank you.
Aka mandemos application na ma ahe. Milan commission plot shpoje ha me. Na me plot shpoje se ke yin. Number dromo na akumaje bi. One of the mandamus application are grant in 2012. Akumaje ewe careful. Yes, I'm sure that case is in appeal. Na mekeshe.
Right.
Ki akumaje bi ama wo na kan case any honey.
I'm plotting na kan bi yeah, right.
Ama he se shurarai. I can squash.
Yep. I can squash the
mandamus application.
That's right.
Minkwe English alata lehun sani eya feku.
That's right.
Okay. Wo be injagashi alaji wonu muchi wa denje. You wa job.
Yeah, that's right. Yeah, I have a check. Ofane course and e bi mo about ni work me what for 3 hours.
Alaji answer in question.
Oh, okay. Sounds good. Alaji, oyana walada ofane ekomeku kaji woye na agbe kun ye ibalemla agbe o wa fun ni de watch bu ego ni wa job wa reje.
Yo,
over you. All right. So cheme we no ko bedon nya ni won mai mo alo akuche we no ko afita yi.
Obe biere ye ni bi ase be woto woke wo pa ri ji se bia kesi echo forgi le ba ton ni ibaye ke domoshi ila kesi there's a chance
yeah
there's a chance alaji mi bla mo ni e bla fe eyi ya kesi si eyi ya be bo ami ni Sempe ebo tu wa denche ekwo keje nye ekwo wa denche onumji wo lewun echo forgi le ba nye echo ni enye ni ke chimo buji yen ni acha
right Right.
One pale fire wa denche. Ya kashi kaji de kanu kone e sempe bi ade be no le be wo problem.
Mhm.
Be wo problem wa denche. Be agbene le be ayehin wa so kere ya agbene. Ba ayehin wa ni ene wa fe o kadi noko ke hale akashi e katashi ne gadi bi kuma fe shomo keke. Akeni eke tase no ni igleke e pon sempe pon fe ke sempe ni bi ko mene katashi because numo emecho emme ne keni bi ne emme keni bi no affect le bi ana ni that big time wo ene acho no ni ni bi ko me ni enye efi awo ye ko ni edomoshi
nakai
cha ni o manye bra of
ya chemega jeme wanda nyeshi wa de nche nyi wala don wo I guess no embawa so okay ba we gule wo nya anuchumo kenya anuchumo ni yeshia I don't know if I get bored but I will see but minda nye fenshi gbese manye funeral wo cover ko Tuesday wo ba cover lege case no there are other DB communities and get chonya akola che boni ejale border so week ne wo ba kwa ko ba felu some of the cases komeni judges come AUA explicitly ake nakanjeme sempe no your case is komani. You understand? I will show you some of them this week. So like I said, all hope is not lost for sempe. It's all about the legal strategy. The way ni alaji ehame weapons p. So ni sempe over the call but I hope I got know some of the things ni wo lawyer echitan bona kenye lawyer a discussi ni akwaka abanya bole na kan case se ko na kwake mini te aba fete na abanya infuse into review ni nyete nye kwake no ko banya echake logo Gbawe bi ele amengba ame yin aye Gbawe bi ame mbombo class
ame sulake ba ye ame sulake ba
ame mbombo class
ame bajata da wo ame pipra me da me ba
that's right
wo jata awakumo jata you know jife ka jata gbe yin
that's right all right so chemega nyeme nyefe nye yana wala da obasa oba pe later on in the week o find ke oye BFN ka je southeast all the way up onto the northeast. I'm pleading with you, please stay safe. This is going to be bigger. Projections say right. It's going to be bigger than the one we had 3 weeks ago. So, Ofaine, Kajekpo, do not go out. If you have no business going out, don't go out. I'm pleading with you. Ofaine, your life is very, very important. Kenhawo. So, Ofaine, all the way from the southeast, all the way up to the northeast. Don't go anywhere. It has already started. Stay indoors. Nyefenye kwa nye no ojogba. Obasa obakpa ye bi eko during the week. Nyefe nyumba jonye ochine miye eswele nye eya nunyam akpa nye no. Ebunye biai, ebunye hoai, ebunye nuchumai. Yani no fe no nye ba fo ochine miye efe no ya ke swele mo eya nye. Nye yana walada obakpe. Bye bye.